this experience certificate issued in the name of Satish Kumar Singh on RTI application made by us with regard to experience with regard to rail rake handling of transportation and handling of the commodity, that also fails to meet the yet, my lords. Now, once we received the information, we gave, my lords, a written objection signed by 11 people. Because 5 of them withdrew that application, maybe under pressure, and therefore this objection of us was not even considered and not even taken, contract granted, continued. Not, that's not the only objection. Let's kindly turn to clause 20 of the NIT, which is at page. Notes, I have quoted that in my notes. Notes in English version, your lordships will kindly see, my lords. If your lordships will see that quoted portion, my lords, relevant clauses I have tried to, my lords, make it convenient for your lordships to refer. This is, my lords, at internal page 5, clause 20. It was right at the bottom. Kindly read this, my lords. The bid of bidders. Lords, has your lordship got that notes which I have given, my lords, a list of dates and clause 20. The bid of the bidders, contractors furnishing wrong, forged information, documents, certificates, affidavit will not be held to be valid. During span of time, if the information, document, certificate, affidavits, etc. would be found to be wrong, then their tender would be held to be invalid and will be cancelled, and the same amount as deposited by them would be forfeited and action would be taken in accordance with law. Now, we have talked that we have submitted a written objection based on RTI information to the respondent authorities. Lords, respondent authorities chose not to act on it, turned a blind eye to it, which is itself, if not to say the least, indicative of a connivance which should not enter into grant of purpose.
What is their stand in the counter?
Lords, with regard to 19-122 objection filed by us, they say 5 of the 11 withdrew, and therefore
5?
There were 11 people who had signed that written objection, and 5 of them withdrew later. Not naturally under pressure, your lordships. 6 of them continued to hold that, and yet they say since 5 withdrew, it's good.
How is it relevant if they 5 withdrew? No, what is their counter?
Because counter may
whether 6 respondent fulfill this.
They say yes, the counter affidavit says that the tender was carried out in terms of the provisions of the notice inviting tender, and it was done in accordance with law. That is all.
Then we will find out from the record. Yes, who is appearing for Food Corporation?
Warehousing Corporation.
Yeah, State Warehousing Corporation. Where are the records?
They are here, my lords. Court may have, but it's called by, specifically called by a judicial order, my lords, if the lordships will.
Where are the records?
Those are submitted to the court process.
Submitted to the court? When?
2nd of January. January. 2nd January.
This matter was heard beyond by
No, records were taken.
Report was called for by.
No, called for. Whether it is presented and it has been recorded that we are in receipt of record.
No, it's not recorded. Kindly see the
And the records. Where are the records? No, before the court means it. The court has accepted record and kept in custodian. Where is the order? Where is the order? Judicial order.
The order we were only directed to file affidavit. The successful bidder was directed.
No, sir. Where is the original record?
That I think it.
They will answer.
Done should be something. They must verify it.
On what date it was recorded?
4th January.
No. Kindly see,
January 23.
Kindly see the order dated 2nd of January 2023.
Right, 2nd January.
But on 4th what? January. Matter was listed. When did you hand over the records?
Next week.
उसके बाद तो हुआ नहीं।
Only 4 हुआ जमा हुआ next.
उसका दूसरे पे
Because the judicial order calling for record is dated 2nd of January 2023. That's order number 3.
Who is counsel for Bihar Warehousing Corporation? Sir, you don't have instruction whether on 4th January you are required to produce the original records with the court master. Have you furnished it?
That was produced also.
Huh?
Produced in the court.
Where is the acknowledgement given by the court master?
That is not given.
Then how can your original record be placed with the court master? You file an affidavit. Who has filed? Who has produced? Yourself. So file your affidavit by tomorrow. On 2/1/2023, the following order was passed. Pursuant to the aforementioned order, Council for the Bihar State Warehousing Corporation stated to have handed over original records on 4th of January 2023 to the court master. In this regard, he is hereby directed to file his personal affidavit, to which court master he has handed over the file on 4th January 2023. Further, such handing over the records of the subject matter was under due acknowledgement or not, for the reasons that perusal of the order sheet, nowhere it is recorded that the records have been furnished by the Bihar State where from 9/1/2023 onwards. Release this matter Wednesday.
That will be on Monday, my lord.
Wednesday.
No, it's the same order with regard to the next case.
Huh?
Same order with regard to the next matter, which is arising out of the same tender notice. In that case, also by the same order, records record
No,
for.
not the same case. In that case, suit is filed.
All right, we'll see the file.
That has
इसमें भी
We'll see the file.
In the order.
in both the cases suit filed they had
No, let us see the order sheet.
yes my lord.
Order sheet देखिए same date में आप लोग क्या
the injunction was granted by the trial court. That is stayed by the honorable court.
Lord
We are not concerned with that. We want a record.
WJC number 1609. See the order dated 2/1/2022.
No, in this case, there is no order.
There is no order, yes.
That is his case. My case is CWJC number 13609.
That is serial number 7, my lord.
That's serial number 7. One 1362123. Both these cases, my lords, were heard together simultaneously.
Third case, this case.
In this same the order is there.
Lords, I have been told, my lords,
13609 of 2022. The concerned council for
Bihar State Warehousing.
the Bihar State Warehousing Corporation is hereby directed to file affidavit in the light of the order passed in CWJC so and so. Two affidavit.
Lord,
item 6.1, serial was number 1.
In that there is no order.
Lord, Lord, there is no order, Lord, the matter is identical for the reason that, Lord, that only the place is different. Lord, it is Singeshwara Sthan, Lord,
The seat
housing center.
18363 of 2022.
Only the place is
For the Bihar State Warehousing Corporation is hereby directed to secure original records relating to subject matter of litigation.
Okay.
Entire record.
Okay.
The heading for admission serial number 8, Neat, Lal and others versus Evening of India others for the applicant Sri Ajay Kumar Sinha.
Where is the material to show that you have contributed?
So many annexure in which my name finds mention in the
Show us material to the extent that you have contributed EPF amount.
contribution is to be done by the employer. My lord.
Correct. He has to deduct and forward.
Yes, ma'am.
Where is that? Where is that
So
material?
the counter affidavit, my lord, of the EPF authority, paragraph 10,
Not EPF authority. The seventh respondent.
seventh respondent,
Seventh respondent was required to deduct
Yes,
EPF amount and forward it to the
Seventh-
EPF authorities. Where is that document?
seventh respondent has under RTI information has given me that they are surprised as to how it has not been deposited. Therefore, my lord, that I'll be placing
How?
it before me. That this at writ petition at page 32, my lord.
Second, sir.
The respondent trust writing to its secretary when I complained before him that my name is there, but no contribution is there in the records of this. Then
Then you don't have case. Go and fight with the
please find enclosed here with a
school
letter.
authorities.
Enclosing therein letter in Patna discrepancy. You may kindly like to take appropriate action and intimate the position to S.B. Lyle under the intimation to the S.B. Lyle is the original lead petitioner who worked as a principal. He had
Maybe, but there is no contribution, no?
contribution. The employee cannot deposit the employee. It is for
She
the
being the principal, she doesn't know. She is the principal, no? Then?
the accounting was done by the headquarter, my lord. Only the
File a suit for damages with the management. We are not going to allow your
lead petitioner has died long back. Now the years are
then
coming.
forget. Anyway, contribution is not there.
Lord, the
At least the petitioner should have verified from the pay slip, no? Whether
Once,
it is deducted or not.
once the counter may be allowed to
He is
place.
educated. He can't say that I don't know. One can understand if he is a laborer.
Lord, in the counter affidavit, they say, Lord, in counter affidavit at paragraph 10. See,
Sir, in the absence of contribution, where is the question? Internal correspondence.
employee authority could
That's the reason you file a
compel the authority, the employer.
suit for damages against the management.
The employer can even today be compelled to deposit the contribution.
Not at this distance.
Here being a beneficial legislation, my lord.
No. Further, you have to pay interest. Assuming that 1,000 rupees. If your contribution is 1,000 rupees, then employer has to add certain percentage.
Once I have made a complaint to the EPF authority, and the EPF authority acknowledges that my name appear in the salary register, but still since the deposit is not, therefore I'm not extending.
Correct.
Therefore, my submission is that the employee permanent authority has enough power to enforce the benefits of the EPF Act, my lord. And then
So as the power under EPF.
17. Lord, I will assist your lordships. I will bring some.
There is no provision, sir.
Case law.
There is no provision. They have two options. They should have taken action against the management, stating that you are engaged more than 20 employees. Therefore, you are liable under the EPF. Quite naturally, they have already submitted on behalf of other employees are concerned. They have left out your name. We don't know for what reason.
Lecture 1 is the list of employee in which my name mentions below.
There shows the deduction. Time to time deducted EPF contribution from you.
That information is.
Further, assuming that even if they have deducted, further management whether they have remitted in the EPF before the EPF authorities or not.
Therefore,
or management has followed, we don't know.
Therefore, by the last order, this honorable court has been pleased to.
Sorry, sir.
That's the notice to the management also, but they are avoiding this proceeding.
That's the reason you can file a suit for damages against your management. At the same time, they will ask you why you did not open your eyes when the cause of action accrued on so and so date.
The original petitioner was under an impression that she being a member and.
Sir, payslip you will get or not?
There is nothing like payslip.
What? Nothing.
Sometimes payments are made 6-month arrears. They don't pay regularly because it was a private employment.
You have surrendered your rights to the management in the guise of employment. Is taken in the instant LPA. Appellant has assailed the order dated 10/2017 passed in CWJC 21702 of 2014. To stop. Mrs. S.V. Laila, like all. Retired as a principal,
Original writ petitioner.
Angus Girls School and Women's Training College, Dodipur, Patna. Claim that she is entitled to EPF and other ancillary relief. The single judge has rejected the claim of the deceased employee on the score that she had not given, she has not submitted her contribution towards EPF. So also management of the college have not deducted EPF contribution of both deceased employee and employer, and further remitting the same before the EPF authorities. The absence of any material information, the claim of the deceased employee by her legal heir is without any substance. The same has been taken note of by the land single judge while rejecting the CWJC 21702 of 2014. Land counsel for the appellant submitted that Annexure 1 and Annexure 10 suffice that certain correspondence was invoked. Merely there were certain correspondence does not inure any right to the deceased employee so as to claim EPF and ancillary benefits. In the light of these facts and circumstances, appellant has not put out a case so as to interfere with the single judge order dated 16/10/2017 passed in CWJC 21702 of 2014. Accordingly, LPA stand dismissed.
Last order, Section 8 of the Employees Provident Fund and Miscellaneous Act may kindly be seen. Section 8 of the Employees Provident Fund and Miscellaneous Provision Act may kindly be seen. There is a mode of recovery. Recovery from the employer.
Recovery from the
employer of an amount payable to the employee.
In this regard, you have to make an application before the authorities.
I have made the application.
Then pursue that. They have to.
Then we have come before this.
Then they have to invoke 14B, inquiry and all.
They have refused to make inquiry when they said
then
that.
You have to seek a direction for initiation of inquiry.
That is the direction in the writ petition, my lord.
No.
Yes, my lord. The writ petition, the prayer may kindly be seen.
The reliance on Section 8 is also misconceived because Section 8 comes into play only when there is an assessment under Section 7A. When there is assessment of dues, only then, my lord, there is assessment of recovery under Section 8.
no prayer. You want me to read the prayer?
To issue, to grant pension from due payment.
No, you are asking for payment.
I was not. Yes, not that.
Please don't give misunderstanding or misleading information to this court.
What I say that he has rejected my representation, saying he could have.
Have you requested the authorities stating that here is a school
Yes.
which more than 20 employees are there? They must investigate and collect EPF amount. Such a complaint is there.
That has been investigated. EPF number was given to the school.
Where is the document?
No, that is an actual one. Is the first information which was given.
Upon that, you should have made a complaint to the authorities.
Annexure 1 may kindly say the name. My name is mentioned there in the list of employees, my lord.
All right.
Then after retirement, I made a representation.
Take out the original and put a frame and hang on the wall.
Serial number 9, Ganesh Prasad versus Vijay Kumar Verma and others for the P&C Pramod Mishra.
By the last order, Lordship, we have complied the order, Lordship, the online, I have filed the online Lordship petition. We have filed the online petition, Lordship, but I failed to file Lordship a hard copy, Lordship. By the last order, Lordship will end.
You are representing state.
No, Lordship. I am
You are representing Ganesh Prasad.
Lordship.
All right, argue the matter.
Lordship,
You don't have file.
Lordship, I am extremely sorry, Lordship. I have been instructed by the Mr. Lordship Pramod Kumar Mishra Advocate. Lordship, seek adjournment for 1 week, Lordship.
Who is the appellant?
Appellants are, Lordship,
Ganesh Prasad.
private respondent in the writ petition, Lordship. They were private respondent in the writ.
Writ petition is allowed, is it?
Lordship.
Who is appearing for Ajay Kumar? Ajay Kumar Verma. Notice have come to know that. State also filed LPA.
Lordship, I have no objection whether LP has been filed or not.
No, there is the order.
Then I'm going to verify, Lordship, whether LP has
And
been
it is
filed.
given to a different council. That is the system here in the office of the Advocate General. One file is given to X, another file is to Y.
Lordship, I'm going to verify whether LP has been filed. From the order dated 27/6/18, it appears that LPA is going to be filed by the state.
You are appearing for the appellant.
Lordship.
You are not complied. Order dated 3/2/2020.
Lordship, that has been complied. Perhaps that has been complied.
Where is that? Documents.
Documents online file has been made, Lordship. I have filed the online file, Lordship. That has been filed, Lordship, but hard copy I failed to file, Lordship. It may come after 1 week, Lordship.
For what purpose?
Lordship,
Again, for adjourning the matter.
verifying the fact whether the Lordship online that has been filed, Lordship.
To notice to this, respond by 1 and 2. Necessary requisites shall be paid by the appellant within a period of 1 week from today. In the meanwhile, the appellant counsel is hereby directed to furnish hard copy so far as compliance to the order dated 3/2/2023. To state counsel is hereby directed to ascertain whether is there any LPA prepared by the state or not in the state of hearing. This matter after 2 weeks. 3 weeks.
Notice must be filed within period of. Notice must be filed within period of.
Which notice?
Private respondent.
No, it is for the appellant.
Lots.
1 week.
Lots.
Serial number 10, Mrs. Scott Edel Pharmacia Limited and another versus the state of Bihar.
Lord, in this case, Lord, on behalf of the respondent, just I received the entire file with the approved counter affidavit. Only by today it will be getting affidavit and I will file online with a copy to the petitioner's counsel. Only 1 day accommodation to file this counter. Approved it, we just received.
In compliance to order dated 27/3/2023, concerned respondent intends to file counter affidavit during the course of the day. He is permitted to file a hard copy in the registry after serving a copy on the other side. Release this matter after 2 weeks. In the meanwhile, petitioners are permitted to file a rejoinder if any.
One thing I may request, my lord, if it is for 2 weeks. Then, although I submitted in course of day,
What file in the registry?
it will be by tomorrow.
No, today only.
Obliged to Lordship.
Our order says that.
Yes, obliged to Lordship. I will be doing.
Serial number 11, Mrs. Raghav Sivcon Private Limited versus the Union of India Others for the petitioner Sri Rashki Prasad.
An application to close the agreement and refund the earnest to.
How do you explain delay 8 years?
Actually, agreement has been closed.
And you are asking for a writ of mandamus to close the agreement with reference to 14/12/2010. You filed such writ petition in the year 2018. How do you explain 8 years delay?
The pendency of the application itself,
What application?
this writ application,
Huh?
agreement has been closed.
Close. So writ petition has become infructuous.
Yes. And only grievance
for the petitioner.
Only grievance is that.
No grievance. If you say any grievance, I will reject on the ground of delay. During pendency of the present petition, petitioner grievance has been stated to have been satisfied. Accordingly, the present petition stands in course of further. If any dispute is involved, he is permitted to invoke appropriate remedy.
Serial number 12 is adjourned for 2 weeks. Serial number 13 is adjourned for next week. Serial number 14, Nawasiz Prasad Singh versus the state of Bihar for the petitioner Sri Shiv Shankar Sharma.
we have filed an application praying for extension of the time granted by my lords by 4 weeks. We have filed it online, and hard copy has just now been filed in the registry, my lord. 2 documents my lords wanted. One we have brought on record. One is still remaining, my lords. We are not being able to serve.
What is this, sir? How many times we have to adjourn?
My lords, we are not able to get it, my lords. We have written to the General Administration Department, Finance Department. We have searched our registry, my lords. We have made efforts, my lords. It's not that. And
Order to the others.
my lords, I am extremely sorry, my lords. They're very we can't explain it, my lords, why you can't get it. And that IA, therefore, we have filed because my lords was pleased to give us last indulgence.
For the rest. For number 6, Patna High Court. Further time. So that to comply order, older resolutions are required to be older, documents are required to be traced out and furnished. Release this matter after 3 weeks as the last chance, failing which the matter would be decided with the available records.
Much obliged.
Petitioners are all senior citizens, long back. You understand?
Serial number 15, Amit Kumar versus East Central Railway, who is Central Manager for the Additional Vikas Kumar.
Who is for the petitioner? Respondent?
Serial number 14 for the petitioner, Sri Vikas Kumar.
None appears. Matter is of the year 2018. The petitioner has assailed a notice dated 31/7/2018. Prima facie, the present writ petition is premature, for the reasons that notice could be challenged in Article 226 only on the score that if there are any violation of rules or notice is issued by an incompetent authority. Both the ingredients are not forthcoming from the pleadings. Therefore, one has to draw inference that the present writ petition is premature. Accordingly, writ petition stand dismissed as premature.
I am appearing for the railway, Your Lordship, respond to the railway in this case.
Why are you not opening your mouth? You are just standing.
I was searching for the petitioner, Your Lordship.
Why are you more interested in searching
The
for?
counter affidavit is ready, Your Lordship, that has not been served. That's
What is the new development after notice?
The counter affidavit has been filed, Your Lordship.
What is the development, sir, after notice? There is no interim order.
No, Your Lordship.
Then are you not required to act upon your notice? After disposal, you are saying that show my name. What is the consequential?
Just I have not gone through, Your Lordship. It is actually what contract to be served and he want to take a time, Your Lordship. That's the reason.
Sorry. So at this stage, then counsel for the respondent railways appeared and he do not have the later development after issuance of impugned show cause notice. Accordingly, the plea has been rejected.
Matter file of serial 16 is
17.
yes. Serial number 16 file is not available. Serial number 17 Rajiv Kumar Singh versus the state of Bihar for the Krishna Sri Manish Kumar number 13.
Lordship, in this case, just want 1 week further time, Lordship.
Contract was for 2 weeks.
Last time we have made it clear that we have no locus and last opportunity.
Pursuant to their advertisement, Lordship, I have applied, but thereafter it appears that the government have changed the policy. In the pursuant to advertisement, which is Annexure 1, Lordship, the petitioners have applied, but thereafter it appears that the policy was changed by the government and it was directed.
Lord sir, this contract was for Lord's running the tube well and all that. Now Lord's the policy decision is taken, now this will be transferred to the local self-government. He is challenging the policy decision, Lord's, and Lord's now, as of now, Lord's the period.
What is Annexure 3?
Annexure 3 is by which the policy was changed, Lords.
Where is that? Annexure 3?
33. Case 33.
What is the date?
Date is, my lord,
4/2/2019.
4/2/2019.
And the advertisement was of 12/8/2018, Lordship.
What is this policy?
Policy is, Lord, the government used to, Lord, initially, Lord, the department used to, Lord, advertise, and then, Lord, the contractors were being allotted for this responsibility to, Lord, run the tube well and all that.
So,
How
Lordship,
your right is affected?
Lordship, by Annexure 4, Lordship, my contract was cancelled due to the Annexure 3, Lordship. Before expiry of 2 years, Lordship. If you, Lordship, will see...
Have you questioned your cancellation?
Lordship, my contract was cancelled by Annexure 4, please, Lordship.
What is the date?
Cancelled the...
25/10/2016 or 18?
18, Lordship.
18?
18.
What is the reason for cancellation?
Cancellation reason is, Lordship, that now the policy have changed.
No, policy is introduced only in 2019. Before that, how can they cancel? Don't say something which is not there. You have to read and come. What is the reason for cancellation of your contract? Yes, what is the reason, mister? No reason. Then we'll set aside.
We'll have to file counter affidavit also.
How many years you want for filing counter affidavit?
Last time, my lord, had questioned, the locus of this petitioner, therefore, my lord.
So what?
Lords, what?
We may not interfere with the change of policy, but we will interfere with the cancellation.
Lords,
Cancellation.
from plain reading of this, Lord's cancellation, it will appear that, Lords, the background of this change, Lord, it is only that policy that by which, Lord, they have decided.
Before policy was introduced, the contract cancellation, how is it permissible?
Lord, power to, Lord, give this strengthen, Lord, the local.
Sir, as on the date of cancellation, new policy was existing. That
no, Lord, it was not.
Huh?
It was done, Lord, that policy decision taken in the midst of it. in the bids also.
You pay damages, whatever you want.
Lord,
Where is the agreement?
it is they who have been given, Lord.
Huh?
Lord, Vijay Kumar to aap hi lo.
No, we'll allow the petition partly.
My Lord will appreciate it. They are saying, Lord, something different. My Lord is saying that
Agreement
it is the
is an
same person who have been, Lord, relegated to the local self-government. Because they are doing it, but only the control
You
of...
have cancelled the contract or not?
No, my Lord will see, it is not a cancellation. Now the Sanchalan and everything will be done by the local self-government. That is only, Lord's control power is only given to the...
File your affidavit. Who is the author of this cancellation?
Lord's executive engineer.
Executive, yes, take on respondent, executive engineer. Who has cancelled the, who is the alleged to have cancelled the contract of the...
My Lord is using word, Lord's cancellation. Yes.
Please understand, alleged cancellation of contract is hereby directed to file his personal affidavit as to why the process of execution of contract in favor of the petitioner has been stalled before Annexure 3 dated 4/2/2019 within bracket new policy was introduced. Such affidavit be filed before the next date of hearing, list after 2 weeks. कुछ नहीं देते क्या? Who has received? Which court master has received? Huh? Has he not written in the office note that he is in receipt of court in this document? Is it not necessary to record on the file? On the right hand column there is a column, no? Find out whether it has been mentioned, recorded in the audit report. Very bad. the same petition. They have tagged it. They have to inform them. The court master will ask the respective counsel. They have received either the court master has given appointment or the advocate has obtained appointment. But
दोनों सवा दो
12:15. Call next.
Serial number 18, Mrs. Jayama Durga Travels versus the Union of India for the petitioner Sri Varun Kumar Trivedi.
Yeah, please, my lord. It has not yet come in this case.
Who is Ramdar Shekhar, Railway Council? There is no representation on behalf of the railway department on 13/3/2023, 27/3/2023, and today also. Further, counter affidavit has not been filed. Therefore, respondent number 4, the General Manager, East Central Railway, Hajipur, Safety, the General Manager, Safety, East Central Railway, Hajipur, are hereby directed to appear in person. Complete records. To release this matter after 2 weeks.
Serial number 19, Mrs. D.K. Chaudhary and Company versus the State of Bihar for the petitioner.
My lord, may you please. Lord, I could not file supplementary affidavit, my lord. 2 days, my lord. Further time may be granted, my lord.
What supplementary?
My lord, earlier occasion, my lord, honorable court was pleased and lord, filed the supplementary affidavit on the ground of mentality of this writ petition, my lord. Writ petition, my lord. And I have prepared, my lord, through the case law, my lord, but I could not finally submit the, my lord, supplementary affidavit, my lord. My lord, 2 days, my lord, time.
These are all disputed issues. Go and file arbitration or whatever in terms of clause 25.
My lord, but my lord, arbitral action, my lord. So my respondent action is my lord, one, my lord. One, my lord. agreement. (22), my lord.
Where is clause 25?
This is
Why you are not putting the complete agreement copy?
This is the standard form of contract, my lord. SBD, my lord. This, my lord, document is much voluminous, my lord.
So what? At least extract, relevant extract should have been produced, no?
Then I will submit, my lord, by way of supplementary.
What is the reason for revoking the agreement?
My lord, this is the, my lord, page number 27, my lord. This is the relief, my lord. Due to flood, my lord, excessive flood, my lord, process of the, my lord, construction.
So therefore, it is a disputed fact which cannot be adjudicated.
The government assessment, my lord, 28 lakh rupees damaged caused by the heavy rain and flood, my lord. And my...
Sir, these are all the matters which require to be adjudicated before the arbitrator. And this court cannot examine whether flood has taken or not.
My lord, this is the government, my lord, assessment, my lord.
Sorry.
I am not disputing this, my lord, and extra, my lord, page number 27, my lord. I am only saying, my lord, that this particular, my lord, is admitted, my lord, fact considered, and I am still ready to complete the contract, my lord.
After how many years?
My lord, this is still pending, my lord. On the part of my simple grievances, my lord, my lord, caused, my lord, damage.
Yes, where is the clause? Clause for with forfeiting of the EMD amount?
Your Lordship, I wanted to pray that my brief has been misplaced. I just wanted to reconstruct the...
You are also sailing in the same boat.
Your Lordship, it has been misplaced. I was to submit that before that.
And counsels for their respective parties seeks time release this matter after 2 weeks.
My subline.
Produce the relevant portion, otherwise we are going to throw the papers for want of material. Crux of the materials you don't want to produce. Relevant portion you don't want to produce. Only first page you have produced. There was an agreement. That's all.
Serial number 20, Navodaya Vidyalaya Samiti versus Sunil Kumar Singh for the traditional Patna.
This matter is covered.
In this case, no, I have filed civil review application there, Milan, that are three civil review applications are there, Milan. The case of the petitioner is Milan. They were the employee of the
Panchayat teacher.
The spouse are Panchayat teacher, Milan. The dispute before the learned tribunal was not with respect to their status, Milan. The dispute before this honorable court was also not with respect to their status, Milan. The dispute is, Milan, whether they can be given the benefit of spouse facility or not, Milan.
The spouse?
A spouse facility.
Where is that spouse facility?
Milan. Now, Milan, I have enclosed, Milan, annexes S6.
Your original application.
I'm sorry, I am respondent here. I am respondent in the first case. In petitioner is civil.
Where is the original application?
My lord, the writ petition is covered by my lord's order.
Sir, counsel, where is the original application? He is disputing. Therefore, we want to see the prayer.
Lordship, why was filed in order?
Sir, you please answer. When court is asking you something, you say yes or no. You can't simply ignore. What is the court is asking you? Where is the original application filed before the CIT?
That will have to be.
And you are saying that matter is covered.
That will have to be brought on record.
Well, you must say so, no? Can't you understand or what? And counsel for the petitioner is hereby directed to produce the original application filed by the respondent before the CAT in order to ascertain what is the relief sought by the respondent petitioner. You have not read the papers. See, you have produced. You have not read the papers. You have come here. That matter is covered.
Lordship, have already disposed of 11 cases similarly situated. Therefore, Lordship, I'll just check the records.
Strike off everything. And counsel for the petitioner. Dash Union of India is not prepared to address the argument on merit. Read this matter next week.
No.
of the entire finance.
Where are the IAS?
941. One is 940, page 940 of the paper. That is volume 3. Volume 3.
Below that page 941 is the prayer, the amended prayer below. The amended prayer. But directing the respondent authorities to cancel tender bearing e-tender number so and so 2022 and 2023 invited on 5/4/22 as the confidential information and papers of both technical and financial of the bidders so submitted by them with their respective tender documents was leaked in connivance with officials of the department during the...
What is the material to show that the information was leaked?
Willows will show.
And connivance with officials.
Because in fact, those documents are very much on the record, Willows.
Then we have to summon the record. Have you requested for summoning the record?
Yeah, no, my lords, that formal prayer has not. But we have annexed those, my lords, we have stated those facts in the original writ application itself in paragraph 37 of the writ petition. And my lords,
so what material you have produced in order to establish that the tender documents was...
Lords, yes, we have said so. What has happened, my lord, is that we send certain confidential documents, my lords, on the email of the concerned authorities of the official respondents. Now, what the official respondents have done, that they have forwarded that document through their email ID to the respondent number 4.
Have you included such officials as parties?
Yeah, my lords, they are part. They are part.
No, which official has leaked these information?
Lords, that was sent through email. No, this email is of the officer respondent.
You have to include him as party.
So, Lords, the officer, the director, email, director officials.
All this is ploy because petitioner of this case and respondent number 4, they were, my lord, the contractors from before. By virtue of interim order, they are continuing. And the State Health Society, as a result, my lord, the State Health Society and Public General is suffering a loss of 2.67 crore per month because of continuing. Now, the L1 rate, my lord, will reduce.
So what is the basis to say that there is a loss of 2.7 crore per month?
Yes, my lord, because the rate earlier and now the L1 rate.
Now we'll ask them if they are ready to work for 2.7, whatever they compensate at the higher rates. Let them continue with that arrangement till disposal of this petition.
Yes, Lords, we are ready. We are ready.
We are continuing because there is no respondent number 4, my lords, was granted the contract for the period prior to the notice inviting tender. My lords, I have
a we are aware. No. This order is to continue the previous arrangement. Yes. Have you implemented the concerned official as party?
One, yeah. Because page 1021 below is the email at annexure 28 below, which says AO
102 of which volume?
Below volume 3 below. IA below volume 3. Volume 3. Page 110.
There is identification of volume 3 to 1.
Below. IA
volume number 123. The identification, volume number.
My lords, my objection is that in the writ application, the prayer was, my lord, that his technical bid held responsive and the bid of another respondent be held non-responsive. Now, in course of hearing, when affidavits have been exchanged, he realized, perhaps, that is my submission, that he has no case to succeed. No. Then, my lord, this
leak of documents is
at 1021. My lord,
leak of documents
Yeah.
On what date?
After opening of the technical bid, Milods.
After opening of.
Yes. After opening, and
No,
and it is not
the opening of technical bid.
Not your lordships will
Can this prayer in IA be considered, my lord, in this writ petition? Or it will give rise, if at all, it will give rise to a fresh writ petition? He is now questioning, my lord, an NIT in which he has already participated and his bid has been held to be unresponsive.
All are in the writ applications.
Because all the objections are post technical bid Milods. After the technical bid Milods, everything was known in.
What is the date of technical bid?
Just 21/6/2022.
21/6/2022.
2022.
What is the date of email?
Because email is 30th of June 2022.
That is after.
That is what is our case. That after the technical bid was open, everything was in the open. The financial bid was financial capabilities of all the parties was in the news. It was circulating in the social media. That is the case, Milods. Your Lordships will kindly see at 1021, Milods AO HSBS, Milods, which is respondent number 2, Milods, his mail is being used. Your Lordships will kindly see page 1021, my representation with respect to respondent number 4, if your Lordships will kindly see. 1021.
When you have mentioned some page number, why can't you remove it? There are 2 page number.
With your Lordship's leave,
76 the internal page and 1021 is the running page.
Your Lordship's leave, Milods. Could I give to your Lordships for convenience list of dates?
We have also list of dates. We have also list of dates.
Hand it over. I will pass on the list of dates.
Yeah.
One list of dates to you also. Good master, sir.
जो कोर्ट का है उसको दीजिए कोर्ट वाला कॉपी Lord, these are the details list of dates with all the references we have prepared. Exhaustive, entire facts also we have indicated.
एक कॉपी दे दी. We'll check it up.
ठीक है, कॉपी दे दो सर. हम दे देंगे. सबको कॉपी दो. फोटो
कॉपी दीजिएगा बाद में.
हाँ.
सबको देना चाहिए ना.
And my lord, additional information I may give that on this very allegation, my lord, two more writ petitions were filed, not by him, but my lord, some other persons, and those writ petitions have been dismissed.
Milods, they were withdrawn. If I may inform that also, Milods, the director.
Somebody else.
If I could make one line statement. The key date would be the date on which the technical bids submitted were dismissed. Consider. That is 20.
Kindly see, my lord, these 2 writ petitions were filed only on this issue, leaking of document. And the 2 writ petitions have already been dismissed.
That was in public interest.
Maybe.
So that was in public interest.
Pashupatinath, this organization mentioned in this mail.
Sorry, Milods?
In this mail, where is the recipient, Pashupatinath?
Milods, your Lordships will kindly see the first column, Milods, the second line from the bottom, Milods. By one bidder, that is Messrs. Pashupati Distributors Private Limited.
This is the respondent.
That is the respondent number 4.
Correct. Where is his email address?
Now, ambulance.bihar@gmail.com.
That is his the 4th respondent?
It is his, Milods, yes.
Email ID.
And then forwarded messages, your Lordships will kindly see 1, 2, 3, 4, 5, 6, 7.
No, sir. What is the email ID of Pashupatinath Private Limited?
Ambulance.bihar, Milods, @gmail. And Milods, on top of the very first line, Milods, administrative office at AOS.
ambulance.br@gmail.com. is of Measures Pashupatinath Distributors Private Limited.
Because that is the official under
How
which.
do you say that? That this website number is of Pashupatinath?
This is theirs.
No, correct. But you have to correlate, no? Who is appearing for this society?
I am appearing for society.
This ambulance, Bihar at gmail.com.
किस पेज पर दिखा रहे हैं हम?
Manoj, the very first line of that paragraph, before my lord sees PDPLs, Manoj, the very first
line is with reference to, it is a reference.
Manoj, administrative office of AOHSSB Bihar at gmail.com. Sent from there.
Correct. Address to who? Where is the material to show that it has been addressed to Pashinath?
Ambulancebihar.@gmail is
no, what is the base? That is the reason we are asking. What is the basis? Society has to clarify. Ambulance.bihar@gmail.com.
उनका रिस्पोंडेंट 4 का है, आप बोलिए आपका है
कौन सा पेज पर दिखा
सर? 1021 सर
आपके इस वॉल्यूम में फ्रॉम सम्मान फाउंडेशन. My lord will kindly see.
This is the complaint which has been forwarded.
My lord will kindly see. This is administrative officer to Samman and Foundation. Subject is
from Samman. Yeah,
no, from administrative officer.
But this is my lord. Yes.
So ambulance.br@gmail.com.
Yes.
Who is this person?
Ambulance.com.
हाँ, ये रिस्पोंडेंट 4 का है.
नहीं.
In your reply, what is your answer to this IA?
Yes.
They have not responded.
Because one page before that, 1020, because the financials of Pashupati, respondent number 4, because is in public domain. This is still to be opened. The Lordship will find. We have verified the audited financial statement. This was submitted by them. Pashupati Distributors Private Limited, financial turnovers below so many lakhs.
It is in public domain. What is wrong in it?
Because this was submitted. This was submitted in the financial bid below, which was yet to be opened.
And it's
still yet to be opened.
No, you say that this is publicly it is available.
Sorry,
it is available.
Yes.
Then what is secret? Open secret.
No, this was forwarded.
How does it? Even if my lord that document was there.
All right.
How does it?
All right. Now you.
Yes, my lord. My reply.
Who is this ambulance.br?
I have not checked ambulance.br.
No, your objection should have revealed, no?
My lord,
your objection to this IA must reveal.
Kindly come to my lord. My counter affidavit. I have responded.
No, if it is silent, you have to file additional.
No, my lord, kindly see our counter affidavit.
Sir, we are asking society, sir.
That particular ambulance.
आपने किया.
बिहार नहीं, ambulance बिहार पर नहीं किया.
You file your additional counter to meet this point. This communication is to ambulance bihar@gmail.com.
Yes.
That
I'll file my lord. Otherwise, I have replied that.
And also,
what is related to?
To ask one of the official who is conversant with the matter to be present in the court, so that he will assist.
And the records, my lord.
Respondent number 4, Pashupati.
My lord, one aspect, my lord, will bear in mind. My lord, the health society, which is my lord, spending public money. Previous, my lord, settlement was for.
No, all right, they are prepared to pay the difference.
Yes. The petitioner, only part of the petitioner in collaboration with respondent number 4.
Who is the fourth respondent? Then are you not aware what is the email address of your client? From the document, from the documents.
We have answered that particular statement.
No, all right, you please answer whether the email address is of you or not.
Not kind. 2 minutes since that query comes, it's my first duty.
Sir, first you answer, sir, whether email address is of you or not.
Not kindly see paragraph 28 at running page 718.
You are not answering the court question.
Because that email is ours. But
Say so. That's the end of it. We will not ask the society people.
And kindly see, my lords, with regard to that particular aspect, what we have said.
Under which provision of law this communication has been made to you, fourth respondent, by the
what is
State Health Society Bureau?
What is the communication is of prime importance and then possible.
So what is the, first of all, where is the source of power of this administrative officer to forward this material?
Complaint received against me, which was forwarded to me.
We are not really, I am the sixth respondent, my lord. They have, my lord, given details with respect to a consortium, not in their individual capacity. There was a complaint made against them that they are not qualified.
And therefore it was not forwarded to us.
The content, after declaring them successful, my lord should kindly see the content of that letter.
Because after declaring them successful,
just a minute.
Yes. Why just a minute?
And the date on which it was sent.
My lord, it is very important that they file a reply to the counter affidavit filed on behalf of respondent number 6. If they do that, my lord, all these questions, perhaps the requirement would be obviated.
Respondent number 6 का भी counter file होगा.
हम counter दे चुके हैं सर, उसका reply ये file करेंगे.
हो गया.
सर आया है
उस पे दीजिए.
सपोर्ट कर रहे हैं सोसाइटी.
फाइल कीजिए. किसको? हम आपका सही जवाब दे रहे हैं. You are respondent, you are not seeking relief.
So I'll just place that
not
respondent can't seek relief.
This contents of
You keep your administrative officer present in court on the next date of hearing and also ask him where are the powers, source of power. If any complaint is received by him, it could be communicated to XYZ.
May I also point out, my lord, if respondent number 4 that has been sought to be declared illegally, my lord, successful, if that goes, then we become L1, my lord. And respondent number 6, I may be allowed to make submissions, my lord. I just am trying to expose something which has yet been hidden.
Correct. You'll have a chance.
We'll have a chance, my lord, but this thing is already there. They are not filing any response to this. And the petition is supporting us. We have categorically brought up the fact, my lord,
he is asking relief as respondent number 6.
That we would, my lord, when the occasion arises. What I am trying to bring
respondent.
You have filed your intervening application.
We have been implemented as party respondent. We are respondents already, my lord. And what I have tried to bring to the notice of this honorable, may I make submissions, ma'am? What I have tried to bring to the notice of this honorable court, my lord, is that it is on the basis of incorrect data, my lord, that they are being sought to be declared as L1. We have categorically given the statement that it is the document, the data of the consortium that they are now using for their own individual benefits, my lord, which is just not permissible.
Have you challenged it at the first instance?
No, they have not challenged that.
And after they were declared
What is the claim by the petitioner against sixth respondent?
That he is non-responsive. Sixth responsive, that's what the petitioner IN number 2 is.
Sixth respondent may be allowed to say, my lord, what sixth respondent has to say. Fourth respondent cannot speak.
What is the claim of the petitioner?
The claim of the petitioner, my lord, now subsequently when they are seeking to challenge the entire process, now they are seeking, my lord, to challenge the cancellation.
You are the successful bidder.
My lord, yes, I will. If they are declared as illegal, my lord, because they are using the data of the consortium and not their individual capacity.
My lord, he will
My rights are directly affected.
L2. He says that if L1 is eliminated, then he will become
L1 rightly eliminated
sir,
for
that's
the
why
reason.
But he has not filed.
My lord, I have brought on record everything.
How, my lords, they have at every stage, lords, the terms of the NIT were diluted in order to accommodate this respondent number 4. Lords, had this NIT...
Meanwhile, given undertaking by the petitioner,
Lords,
at the rate of enhanced this thing escalation price, you are
yeah, my lord, we will file a affidavit.
Reduce price.
Reduce price.
We will file the affidavit.
Lord, sir.
And my lords, the record should be, therefore, my lord, from day one, because every day, in order to accommodate respondent number 4, the original terms of the NIT were diluted, because had not that been diluted, respondent number 4 was not eligible to participate on the first day. Except respondent, all others, petitioner and the other respondents were eligible.
My lords, your lordships have heard all of them. 3 minutes to me.
Lords, let the records be called for, nothing.
3 minutes to
No,
me.
my lord.
My lords.
My lords, petitioner, respondent number 4, all of them, my lord, have joined hands, and very, my lord, shrewdly, cunningly, they want this process not to be settled, because by virtue of interim order, they are continuing with the previous, my lord, arrangement, which, as I have said, that the society is losing 2.67 crore per month.
They have given undertaking.
We will file a affidavit.
So all this, my lord, is a ploy only to delay, my lord.
What is the date of NIT?
That was issued, my lord, on 4/4/2022.
And my lords, by 3 corrigendum, my lords, they extended the date of the entire schedules. Let them say why. I'm putting a question to myself. What was the occasion that every time by 3 corrigendum you extended?
I am one lawyer.
Number of ambulances. Please, just a minute. The number of ambulances.
Everything has been reduced to accommodate respondent.
Let me only have 3 minutes. Lords, I am an old school lawyer who reads his brief.
We also read in brief.
I am not saying.
Don't say.
You have all read our brief.
Don't jump.
No, don't. But
Don't
you say
They should not.
No, sir, I didn't object when he was making a statement. He said, please. I do acknowledge he's a senior to me. I call him.
Also, you are also senior. Please don't.
Milords, 3 minutes. Milords will kindly see the point that has been categorically raised with regard to IA is this. 22nd of November 2022 was the date for evaluation of the tender bid submitted. The petitioner till 22/11/2022 till his technical bid was cancelled and holding it to be unresponsive, had no grievance participated. Just a minute, please.
I have not read your brief, I'm sorry.
No, let him complete.
Let me complete, Mr. Singh.
Very well, please.
Milords, on writ petition was filed in December. IA has been filed on 6th of January 2023, basing the entire grievance on the basis of facts already known in the writ petition and said so in so many words in various paragraphs with regard to the leak of document, and yet the relief was only to hold him, to declare him to be responsive and respondent number 4 to be unresponsive. Because this now, your lordships, while evaluating the IA, my lords, in view of the settled provisions which your lordships are well aware.
No, we are not aware of.
My lords, little that I know, my lords, are whether it is imperative is the first question. The second question is whether it fundamentally changes the nature of the case, and more importantly, whether the amendment sought is mala-fide or bona fide. And my lord, fourth, and whether
within their knowledge, as your lordships are aware, a proviso was added to Order 6 Rule 17, which was earlier scrapped from the CPC. And that proviso was added with the intent, as has been with the intent that amendment is not to be granted as a matter of course. These principles are there. We are prepared with. Now, more importantly, what fell from my learned senior appearing for the petitioner, I'm talking about Mr. Lalit Kishore, that the terms of the tender notice were changed. There is an affidavit of the Health Society, who is a custodian of document, statement made, supported by annexures, that those amendments were made at the behest and request of the petitioner.
No. Again, I'm sorry. No.
That will be a subject matter.
Yes.
Is it permissible for the petitioner?
Yes. What the tender notice, why clause 5?
No, just because if he has requested for certain things to be amended, so society can carry out.
Notice inviting tender contained 2 clauses. One was a pre-bid meeting of prospective bidders who have got the tender forms, and then a power to amend the terms and conditions which is contained in clause 5 and 6 of the notice. Plus, we'll produce all those.
Then why are you addressing now?
And
why are you addressing now?
Lord, since everyone was trying to make some statement, Lord, not to earn my fees.
Just because
not to earn my fees, only to dispel the wrong impression that was being sought to be created.
A confusion.
We have not formulated any opinion.
Lord?
We have not formulated any opinion.
I correct, Lord.
Just take a...
One opinion my lords have formulated that they will pay at the reduced rate.
Yes, yes.
No, they will
get at the rate.
If they are successful. And Lord,
this period, man.
Not successful, only for the during the
otherwise the tender will take
pendency of the present petition. Interim order is operating since what date?
This 5th December 2022. 5th December. No, sorry, 8th December. No.
8 December. Since 8th December 2022, interim order is in operation.
22.
Whereby the respondent society not permitted to proceed with the subject matter of NIT conclusion. And Advocate General on instruction submitted that interim order, the state is put on the cost to the tune of 2.7 crore per month.
2.6795, my lord, precise.
2.679.
Yes.
2.679. On this point, Land Council for the petitioners on instruction submitted that they are prepared to meet the difference of amount while executing the work in terms of earlier tender. Such arrangement shall be continued on behalf of the petitioner till disposal of the present petition. Till the finalization of subject matter of NIT dated 4/4. In this regard, the petitioners are hereby directed to give a personal undertaking to this court, failing which interim order would be modified. The light of apex court decision, the case of so and so. Next, respondent society are hereby directed to secure the complete records Also, administrative officer shall be present in the court in order to assist in the matter. He is hereby directed to ascertain the source of power in the event of a receipt of any complaint, how it has to be dealt with, whether is it permissible for him to certain material information to X, Y, Z or not, for the reasons that on 30th June 2022 from his office certain information has been forwarded to ambulance.bihar@gmail.com. Whether such communication made by the administrative officer is at the behest of any superior officer to him or not may also be revealed on the next date of hearing. This matter the society is requested to prepare a chart containing the builder's name and other particulars, and lastly, last column must relating to remarks as to whether qualified or not qualified, reasons thereof. If such a statement is prepared and place it on record, it would be convenient for the court as well as to the respective parties.
Lords, just one. Lords, petitioners are a joint venture. Therefore, your lordships will find there are three. Petitioner number 1 and 2 are members of the joint venture, which is petitioner number 3. The work was being executed earlier, which your lordships have directed, not by the petitioners, but petitioner number 2 jointly with respondent number 4 as a joint venture.
Petitioner number
2
and respondent number 4 are hereby directed to give undertaking that the earlier I have given petition, no? Petitioners have to give undertaking. Instead of that, petitioner number 2 and number 2 are hereby directed to give an undertaking.
Please, just 1 minute. Lords, here, for any Monte Carlo case which is dead, given latest judgment. Lords, the petitioners have challenged it. We have not challenged the tender process. Therefore,
then we will modify the interim order. If you are not, you are not accepting the rate.
No. Question of rate is not
there. Sir, you are fourth respondent.
Yes.
In terms of earlier contract, and if I take a decision, are you willing to give undertaking or not?
Then we will operate that. We petitioner and we will pay that.
Now you have an option.
In terms of
Sir, you have an option now, either to continue or discontinue. Which one you want?
Pursuant to Lordship interim direction, the financial bid was opened and we were declared L1.
We are not on merits. We are not on merits. We are concerned with the continuation of earlier.
If the interim order is vacated, tender goes to me and I start operating at
all right, now you...
No, we are willing to operate at a lower rate, Your Lordship. We are willing to operate.
Then give an undertaking.
Yes, we are willing to operate.
Give an undertaking. What is wrong in it?
Actually mean awarding the contract in their favor, madam.
What is
what we are objecting?
Sir, till the disposal of the writ petition, we have to make an alternative arrangement.
Allow us
already at interim direction.
Allow the respondent number 4, since it has been declared to be the L1, we are willing to operate at the lowest rate.
You don't want to declare it.
Then
we are not going to declare.
What argument you are advancing?
Whatever I want, I will.
No.
It is for the court to decide.
All right, sir. Are you willing to give undertaking or not?
Yes, Lordship.
Allow us to just give an undertaking. That's all. Don't say that I declare my L1 and other.
What I am submitting, Lordship, that the interim order is in favor of petition number 1, 2, and 3. The interim order is in their favor. But Lordships have directed that the petitioner number 2 along with respondent number 4 should make up for the difference. We are willing to operate at the lowest price because we were declared L1. Allow us to operate at the lowest price. In case they are successful, they would get the tender.
Lord, kindly see the order. Please, kindly see.
Sir, are you willing to give undertaking or not? That's all.
Lords,
petition number 2 and 4.
Oh, yes, Lords, they are operating. Why?
Petition number.
My lord, the consortium is already broken, so it is not there in existence. It is the petitioners who are willing to work at the lowest.
Sir, we have to obey the interim order given by coordinate bench.
My lord, that is there. But what I was respectfully submitting, my lord, is that the consortium is no more there in existence. And they can operate at the lower rate. The earlier interim order.
Lords, by virtue of court's order, the earlier agreement has been extended.
State also.
Yes, earlier agreement has been extended.
What I am submitting is, Lordship, what Lordship may direct not only the petition number 2 and respondent number 4, petition number 2, 3 and respondent number 4.
Petitioner number 2 and 4 are operating.
Who are executing the work as on today?
2 and 4.
Respondent number 4 is the previous tender and he is continuing today also, Lordship. If the tender.
No, what is the basis to say that petition number 3 is also executing work?
No, it is not executing, Lordship. He is the petitioner.
Then why are you insisting?
He is taking advantage.
No, he is saying only 2 and 4.
And my lord, if in the meanwhile they will file a response to the statements given by us, they are
My
not
lord,
notified, they are not even filing a response to them.
Who has to file response?
My lord, the State Health Society can clarify that it is not on the basis of the data of the consortium that they have been selected. We don't have.
Lordships, the respondent number 6, so far as respondent number 6 is concerned.
We have directed them to secure the record. Let us see the
Yes, okay,
that should do.
We are, my lord, society is interested in getting lowest rate, and the person should be efficient.
Time being, you got the relief.
Yes.
Lowest legally selected.
This relief will date back to, my lord, the first interim date of first interim order.
Yeah, that also will make it clear from 8/12/2022.
Yes.
Has your lordship fixed any date, any time for the next?
All right, 2 weeks.
2 weeks is 24th of April.
Right, wait for
Lords, could it be 25th if your lordship said it's not inconvenient to your lordship? Maybe, my lords, I am not here.
All right, 25th.
Serial number 24, Messrs. RS Construction versus the State of Bihar for the business, Sri Patanjali Rishi.
Lord, I have just now received a copy of the counter affidavit. It may come in the next week. Lord, I'll.
For filing rejoinder, if any, list this matter after 2 weeks.
Right.
Serial number 25, Messrs. Take Care Solution versus the State of Bihar for the presidency.
May I kindly adjourn this matter for 1 week?
Why?
Arguing Council Mr. Abhay Kumar Thakur is not for the purpose of treatment.
My lords, in the meantime, we'll file a contra affidavit because it's being prepared. I mean, we can file it by tomorrow or day after tomorrow.
It has become infectious. It has become infectious. Is there any interim order staying the operation?
No.
Then and seventh respondent has been awarded contract.
Yes, I have no any idea about this case because I
want monetary instruction.
I get only instruction to inform the court.
Prima facie, the present petition do not survive for consideration in view of lapse of time, and so also the order. In order to give an opportunity to learn counsel for the petitioner, release this matter next week. It is made clear that no further time would be granted. You also get instruction. What is the stage?
I'll get
to development.
Serial number 26, the Union of India versus Sonu Kumar for the petitioner Sri Kanak Verma.
Against the order dated my lord 22/10/21 my lord, by which the lauded cat my lord has lauded OA directing the petition.
There is a cat order.
Cat order is my lord at Annexure 8 impugned order dated 22/10 after page 68 my lord. That is the impugned order. After page 68, that is the impugned order my lord.
Your application is belated? Delayed?
No.
Oh, your father died in 2004.
Yes. At that time.
4/7/2004.
Yes.
At that time, he was a minor. Where is the provision that in the event of minor, he is entitled to seek compassionate appointment as and when he attains major? Where is the provision?
My lord, on the apex civil appeal number 988 of.
Don't give all those things. Show us the scheme which provides that in the event of a minor legal heir of the deceased employee is entitled to make compassionate appointment as and when he attains major.
My lord, annexure A5 not. A4, page 31 of counter affidavit. Page 31 of my counter affidavit, annexure A4.
This is the relevant portion. No, this is 2023. We want only prior to 2004. What is the scheme existing? You have produced?
My lord,
Where is that?
That is an petition, my lord.
Annexure 1 to?
Annexure 1 of my writ petition, my lord. That is on page. Annexure 1, page 21, my lord.
No, this 92 scheme is still
92, no, 92 is scheme. Yeah, no, after 2092 scheme.
Madam, as on 2004,
my lord,
this 1992 scheme was existing.
My lord. And after it was.
Where have you pleaded?
Yes, my lord. At page 4, my lord, that the petitioner firmly humbly submit Chief Personal Eastern Railway Calcutta, sir, dated 22/192, issued by the Railway Board, while it is later dated 21/4/192, on the subject of appointment on the compassionate ground cases of the second wife and her wards. My lord, that is Annexure 1. It is clear, it would appear that the Railway Board has clarified that the appointment of the wards of the second wife shall not be considered unless the administration has permitted the second marriage of the ex-employee, taking into account the personal law, etc. Clarified that the second marriage is not permissible, is invariable, clarified in the terms of condition advised in the offer of the initial appointment, and therefore it was advised.
Respondent is son of second wife.
Second wife, at that time, and after but on the 24/192, that was the scheme. Thereafter, on 30/12/19, the scheme has been revised. That is not
1/12/2019.
19. This is not applicable.
Till then, 92 was existing.
Yes, my lord. Only that is the only point, my lord.
But you have produced only one page. This Annexure 1.
I have. Thereafter, my lord.
No, where are the criteria for the purpose of appointment on compassionate ground?
That is clearly mentioned, my lord. That it is clarified that in a case of the page 22, my lord, of my petition, that it is clarified in case of the employee dying in hardness, having more than one widow along with the children born to the second wife, while settlement dues may be shared by both the widows due to the court orders or otherwise, to the second widow and her children are not to be considered unless the administration has permitted the second marriage or on special circumstances, taking into account the personal term, etc. The fact that the second marriage is not permissible is available, clarified in the terms and conditions advised in the offer of initial appointment. This may be kept in view that the cases compensate appointed to the second widow or her wards need not to be forwarded to any railway board. Annexure 5, my lord, page 28, dated 7/192, letter is effective from the date of the issuance, that is 30/12/19 only. And he has died on 4/7/2004, my lord.
2004 appointed in the year 2020.
Don't have case, sir.
Kindly see, my lord,
Sir, first of all, how do you overcome delay? Cause of action accrued in 2004. Department cannot wait.
That time, he was minor.
Therefore, on that ground, we are going to reject. The other ground is 2019 circular cannot be applicable to such of those applications made in the year 2000. First application is made in which year?
All the questions have been replied.
2004.
Para 5, may I kindly see, sir. Para 5.
I have seen it.
Para 5 decided by.
That is contrary to Supreme Court decision. On both count, matter is covered by Supreme Court on the ground of delay as well as the later circular or scheme is not applicable to such of those persons who claim compassionate appointment prior to introduction of new scheme. They are bound by old scheme. Under the old scheme, you have no business. You have no claim. That's all.
My lord, in the case of Triveni Devi, decided by this honorable court, may kindly see.
Now we are going to decide with reference to Supreme Court decision.
Supreme Court, my lord. This is the latest one.
They are not clear. Yes, take on.
Some time may kindly be given.
Don't waste court time. Better concentrate on some other case. Take on.
Because only two sons are there. Their mother has also died.
Fine, sir, the sympathy is not before this court. Sympathy is before the Union of India. We are only interpreting law. Sympathy could be extended in the absence of any law. Our hands are tied by virtue of judicial pronouncements.
At that time, he was minor.
All right, sir, we'll consider. What is the date of first application? This Union of India being not furnished dates and events.
27/11/17, when he became just after becoming mayor.
In 18, he has once furnished.
Huh?
2018, at first representation.
No.
First representation is?
No. 27/11/17.
But list of dates, events does not contain anything. Sir, being representing Union of India, you are not given the dates and events properly. And railway board amendment scheme and some communication and judgment. What is the facts of the case? Take down in the instant petition, Petitioner Union of India and others have assailed the order of the CAT. Dated 22/10/2021, passed in OA number 050/00376 of 2020, along with with MA/050/00143 of 2020. Later, Chandradev Mandal, who was an ex-trackman under PWI/Bamlapur of Malda Division / Eastern Railway, Kolkata. And resident of village Sibdi, Hazra, Hama district Lakhisarai, Hama state of Bihar. Died
My lord, latest
4/7/2004.
Excuse me, my lord. Latest circular railway board का है page 32 में kindly see. Clearly it is written that within 2 years of attaining majority where the case.
Sir, latest circular is not applicable to your case. That is what Supreme Court has held. Died on 4/7/2004. He had married 2 ladies. First wife, Indra Devi. And she had died on 8/11/2000. Married for the second time with Usha Devi, alias Sia Devi. Applicant number 1 before the CAT, the Central Administrative Tribunal, for short CAT. And second applicant, her son, that's Sonu Kumar. Both the applicants filed application seeking compassionate appointment to second applicant, that's Sonu Kumar. Such application was filed, application/representation to GM, General Manager, Eastern Railway and DRM, Malda Division on 27/11/2017. Is more that Sonu Kumar, second applicant, attained major. Please stop. The tribunal proceeded to allow the application while giving the following direction on page 10, para 17 instruct. Feeling agreed and dissatisfied with the order of the CAT dated present filed. Next problem, and counsel for the petitioner submitted. There is a delay and latches on the part of the respondents in seeking compassionate appointment in the year 2017 with reference to death of deceased Chandradev Mandal, ex-trackman in the year, on 4/7/2004. It is further submitted that compassionate appointment was governed by scheme of the they dated 2/1/1992. Annexure A series. Full stop. 1992 scheme of compassionate appointment was in vogue till 2019, till 31/12/2019. Full stop. 1992 scheme do not provide for compassionate appointment to children of second wife of the deceased employee. On the other hand, scheme issued on 31/12/2019 provides for compassionate appointment to children of second wife. The grievance of the respondent Sonu Kumar was required to be examined, was required to be considered with reference to 1992 scheme, with reference to date of his father, with reference to the fact that his father died on 4/7/2004, and the 1992 scheme was existing in the eye of law till 30th December 2019. Therefore, the tribunal has committed error in applying the later compassionate appointment scheme, and so also not taken note of the delay and latches in seeking compassionate appointment. Per control and counsel for the respondent resisted the aforesaid contentions and supported the order of the CAT dated 22/10/2021, passed in OA number 376 of 2020. It is further submitted that as on the date of death of the deceased Chandradev Mandal, ex-trackman, Sonu Kumar was a minor. Therefore, he could not make an application. Therefore, he could not make application for compassionate appointment, and he had submitted application for compassionate appointment as and when he attains major in the year 2017. Further, there is no infirmity in the order of the CAT insofar as applying the later compassionate appointment scheme issued on 31/12/2019 to the extent that children of a second wife are entitled to compassionate appointment. Heard the land councils for the respective parties. Undisputed facts are that deceased Chandradev Mandal, who was an ex-trackman, died on 4/7/2004 when he was in service. He had married Srimati Indra Devi and she was issueless and died on 8/11/2000. Consequently, deceased married for the second time with Usha Devi alias Sia Devi. She gave birth to two sons. One of the son is Sonu Kumar dash responsible 2. Deceased employee died on 4/7/2004. Sonu Kumar and another son were minors as on 4/7/2004, the date on which employee died. Therefore, they waited till attainment of major insofar as Sonu Kumar Wisdom. It is learned that he has attained major in the year 2017. In the result, representation was submitted on 27/11/2014 seeking for compassionate appointment. Thereafter, certain correspondence have been made with officials in not extending the relief sought by the respondents. They were compelled to approve filing the OA 376 of 2020. Their OA and the MA were allowed on 22/10/2021. Thus, the petitioners Union of India and others presented this writ petition. Core issue involved in the present list is whether the second respondent Sonu Kumar is entitled to compassionate appointment or not. Sonu Kumar's father, late Chandradev Mandal, extractman, died on 4/7/2004. And for the first time, application was submitted for compassionate appointment on 27/11/2017. Obviously, for the reason that Sonu Kumar was a minor as on 4/7/2004. Right to claim compassionate appointment is not a fundamental right as held by the Appeals Court in umpteen number of cases. It is only a social legislation to meet immediate harness in the family. In the present case, the respondent's family survived from 4/7/2004 to 27/11/2017. Therefore, there is no need of the hardness in the family is not attracted as on 27/11/2017, the date on which representation has been made for compassionate appointment. Next paragraph. The tribunal has committed error in applying the subsequent scheme issued on 31/12/2019 in respect of application dated 27/11/2017 read with the deceased employee died on 4/7/2004. On both the dates, the existing scheme of compassionate appointment is in the year 1992. The 1992 scheme of compassionate appointment do not provide for compassionate appointment to children of a second wife. For the first time, children of the second wife were permitted to claim compassionate appointment was introduced on 31/12/2019. Therefore, the subsequent scheme for compassionate appointment is not attracted insofar as the Sonu Kumar case is concerned, with reference to date of death of his father on 4/7/2004, read with the date of representation for compassionate appointment on 27/11/2017. Next by Appeals Court. In a recent decision, elaborately considered how compassionate appointment is required to be. provided in the case of so and so, the report. Next paragraph. Similarly, affairs of so and so held that compassionate appointment is required to be informed with reference to date of cause of action, like date of death of employee, read with the application for compassionate appointment, in which it is held that as on the date of death, read with the date of application, is relevant for the purpose of invoking relevant scheme. Therefore, the tribunal has committed error in not noticing the aforementioned judicial pronouncement. Next paragraph. Facts and circumstances, the petitioners have made out a prima facie case so as to interfere with the order dated 10/2021, first with the MA number so and so, and it is set aside. In the result, original application filed by the respondent Usha Devi and Sonu Kumar stands rejected.
आपने
Simply dumping papers in the registry to the court master. Who is to assist?
Serial number 27 and 28 are adjourned. Serial number 29, Prabhat Ranjan versus Bharat Sanchar Nigam Limited for the petitioner's treatment capacity.
May it please, my lord. At the outset, I must say, my lord, there is an interlocutory application, my lord, 1 of 2023, my lord, because during pendency of the writ application, it has been reliably learnt, my lord, that franchisee for Muzaffarpur division has been allotted by BSNL to one Hans Enterprises. Its proprietor, through its proprietor, I have made it a party. As far as main writ application is concerned, my lord, the impugned order
the award of franchiseship to the proposed respondent is pursuant to which NIT?
NIT, yes, that is under challenge, my lord. That is under challenge. Yes, that is under challenge, my lord. Originally, my lord, the impugned order is page 75, my lord.
That event, let notice go to this newly added party.
Yes, only I would say, my lord, just recently it has been allotted, my lord. Just recently it has been allotted to the third party, my lord. The status quo as on today be maintained. My lord, may I say, my lord, only for few facts, my lord. This NIT and all subsequent events are even in the teeth of the Honorable Court's Division Bench order, my lord. My lord may come to page 67, my lord. Earlier, I was a
challenge to the work order in favor of Divakar Kumar.
That I have not got. Up to the best of my knowledge.
You are not challenging, how can we?
No, my lord, I have said, my lord, to the best of my knowledge, I could not get the documents, my lord, that it has been allotted to. That's also, my lord, the respondent will be in a better position to say that proprietor.
File your objection.
Yes, I'm in both in the writ application and in the IA. Your lordship.
Writ you are not filed?
No, because your lordship, I took an indulgence, your lordship, so let me see, because all the time this case, my friend was just taking adjournments.
Yes, two adjournments.
That's what I'm saying. There was no urgency. That's
what is the product? BSNL product?
Yes, they're selling SIMs and selling BSNL products.
Basically, a kiosk, allotment of a kiosk for selling BSNL SIMs. That is also free of cost.
My lord may come to page.
Notice to the proposed respondent. Divakar Kumar, proprietor measures Hans Telecom, resident of Choti Kalyani, Muzaffarpur, on IA number 1 of 2023, filed in CWJC 2250 of 2023. The necessary requisites shall be paid for issuance of notice to the aforementioned proposed respondent within a period of 1 week from today. In the meanwhile, BSNL authority concerned respondent is hereby directed to file counter affidavit to the main petition as well as on IA number 1 of release this matter after 4 weeks.
I persuade only for that all the action of the BSNL is in the teeth of division bench order of this honorable court.
Serial number 30 versus Intelligence Security of India versus
May it please, you challenge the award of the letter of
letter of award to the private respondent. I'm sorry. But we have challenged the LOA that has been granted to the private respondent by way of an IA application that we have filed. Actually, we had not been given that counters have been filed, Malak. The parties have filed their affidavits.
I appear for respondent number 7. The person has been granted the award.
Who is appearing for GSPT?
I appear not for this 3 and 4, respondent number 3 and 4, the company award.
3 and 4?
Respondent number 3 and 4, not respondent number 7 has been.
No, who has issued NIT?
NITBF.
Transmission company.
Transmission company.
That is 3 and 4.
Yes,
you are appearing for 3 and 4. File your counter.
Yes, Lord, we have filed.
Affidavits
The 7th respondent, you have filed counter?
I have filed.
The dates?
Malad. Not the NIT. The NIT was published on 2022. 22nd of September 2022. And the last date of submission of the technical bid and the financial bid was 4th of November 2020. Oh, I'm sorry, 2nd of November 2022. The technical bid was opened on 4th of November 2022.
4th of November 2022.
Hello. And the financial bid was opened on 16th of. There is a dispute with regard to the date of opening because on the eProc site it shows that it was opened on 25th of January 2023, but they say that it had been opened on 16th of January 2023. So the record that we were able to procure from the website, it showed that it was opened on 25th, and the private respondent number 7 was declared as the L1 Malad, lowest bidder. Now, the challenge is twofold, Malad, with regard to the grant of marks to the private respondent. On 2 counts, Malads will kindly have a look at the evaluation sheet, which is at page 113. Petitioner is challenging the grant of marks, Malad, so far as the private respondent, which is at serial number 1, my lord will find Mrs. Rakshak Securities Private Limited. The first, my lord will kindly have a look at the 4th column. After criteria, marks, and then the 4th column, my lords will find Mrs. Rakshak Securities Private Limited. And the petitioner is at serial number 5, my lord, Mrs. Intelligence Security of India.
That's 7th respondent.
7th respondent, my lord.
Petitioner is?
Petitioner is Mrs. Intelligence Security of India, the next column, my lord.
Next column.
My lord. The challenge is twofold, my lord. One is regard to the grant of marks of on criteria of experience, which is at serial number 2. And then my lords will kindly see the serial number 6, which is the presence in Bihar for registered corporate office in Bihar and registered corporate office outside Bihar. So if my lords will kindly come back to serial number 2, the experience of the security services business.
Column number?
Serial number 2, my lord, experience of the. Now it says, my lord, for 5 years and up to 10 years, one will be given 10 marks. For 10 years and up to 15 years, 15 marks was to be allotted, and 15 years to up to 20 years, 18 marks are to be allotted. Now, the private respondent number 7 has been given 18 marks, whereas I have been given 10 marks for experience up to 5 years and up to 10 years, and he has been given marks for 15 years and up to 20 years. Now, if my lords will kindly turn to page 102. The first column is for tender company. My lords have got it. My lord will find Intelligence Security of India, that is the petitioner. And below the third one, my lord will find after Jaishankar Industrial Security, my lord will find Rakshak Securities Private Limited, which is private respondent. Now the earliest certificate that he has given is, my lord will find there are two segments of it, manpower services and security services. All that was required to be looked into was for security services alone, my lord. That is in terms of the tender clause, which is at page 44, my lords will find that. Security services, my lord, the earliest certificate, the beginning of his work, my lord will find as against Hafid, Haryana. My lords have got it.
Haryana.
My lord, Haryana, third column, my lord, Haryana, and the initiation date of a start is 1/3/2018. And the last, my lord, will find that NIT Hamipur, just below that is 31st of March 2023. On the right side column, my lord. Just after that. 31st of March 2023.
That is next column, UP.
My lord, UP. So the total experience that has to be considered is beginning from 2018 and 2023. The tenders were submitted in the month of November 2022, my lord. So between these
2021.
My lord, 22.
2/11/2022.
My lord. So between this, he is not completing 5 years. Yet he has been given 18 full marks.
Beyond 3/11/2022.
My lord.
It's not permissible.
My lord. So he has not completed 5 years and yet he has been given the maximum marks 15 years up to 20 years. Now this aspect of it has not been defended by Bihar State Transmission Company, my lord, in their affidavit that they have filed.
No, otherwise, how many years he will put it in this?
He has put in less than 5 years, my lord. Beginning 1/3/2018 to the close date was 2nd of November 2022. He has been given 18 marks for experience of more than 15 years and up to 20 years. He was not even entitled for those 10 marks, my lord, because he has less than 5 years of experience in security services.
This is outside, no? Outside Bihar.
Outside Bihar also. That is the other aspect. First marks, my lord, that...
First marks 18.
18 he has been granted, my lord. Yes.
He's not entitled.
He's not entitled because I've just shown, my lord, that between 18 and 22 only that he has worked, my lord. Security services. So he's not entitled for all the 18 marks that he has been given. That is for the maximum more than...
So otherwise, how many years he has put in?
Beginning 1st of March 2018, my lord, he has put in slightly more than 4.5 years.
So he is not entitled for this column?
He's not entitled for 18.
Column number 2.
My lord, that is because, my lord, it is only for 15 years and above that get 18 marks.
No, 5 years and up to 10 marks.
My lord, but he has put in less than 5 years.
So he is not entitled to column number 2.
My lord. So he is not even entitled to those 10 marks because he has put in about 4 years and 7 months. Now the next aspect of it, my lord, will find that he claims himself to be a registered, because the requirement was that he is supposed to have his registered/corporate office in the state of Bihar.
Right.
At the bottom of it, my lord, will find
column number 6
in Bihar.
Column number 6.
My lord. Now the requirement was that he should have a registered or a corporate office in the state of Bihar. Now if my lords will kindly have a look at page 123, he is incorporated in the territory of Delhi.
123,
my lord, annexure 17. My lord will find that his certificate of incorporation given under my hand at Delhi this 10th day of May 2007. And if my lords will kindly come to page 124, this is an authorization letter wherein they have specifically held in the resolution that they have passed by the board of directors. It says the resolution so and so passed on 2nd March 2022 at 1100 hours in the board meeting held at registered office of Rakshak Securities Private Limited, so and so. Now that apart, if my lords will kindly come to.
No, the registered company is in Delhi.
He is registered there, my lord.
But where?
In Delhi.
No, registration is in Delhi.
My lord.
But registered office?
Registered office is also in Delhi, my lord.
Where do you get that?
My lord will find that at page 124. This is the board resolution, my lord. 1100 hours board. Now, not only that, if my lords will kindly have a look at page 17 of the counter affidavit that has been filed by the private respondent. I'm sorry, my lord, there is no pagination as such. So we are not able to.
Counter affidavit by whom?
Private respondent.
7th respondent.
My lord. My lords will find at page 17 thereof, this is memorandum of association of the company. They say the registered office of the company will be situated at the National Capital Territory of Delhi. And my lords will kindly have a look at the rejoinder that we have filed to the counter affidavit that has been filed by the respondent number 7, which is annexure 18, page 13. This is what we have down, my lord. This is the rejoinder to the counter affidavit filed by the 7th.
Page number?
8. Page number 13, my lord, annexure 18. My lords will find that his website itself shows that he has his registered office at plot number so and so, Dwarika, New Delhi, and the corporate office at 302-309 Tirupati Plaza, Pocket 4, plot number so and so, Dwarika, New Delhi. So both the corporate and the registered offices both are in Delhi, my lord. So his presence is not within the state of Bihar, but both registered and corporate office. Now what the respondents are submitting that his business office is here in Bihar. So we have given him the full marks. When the requirement was registered/corporate office. If my lords will kindly have a look at the requirement, which my lord will find at page 46. My lord will find that at the bottom, presence in Bihar, the requirement was that he is supposed to have registered/corporate office in Bihar. Anybody who's having the registered corporate office in Bihar, he is entitled to 10 marks, and one who's having corporate registered office outside Bihar is entitled to only 5. So between these two grounds, my lord, our case is that he was not entitled to, so his marks would come down. If my lords will kindly see the evaluation sheet, from 98, he comes down to 83. Comes down to 83. My lord will find the total marks obtained out of 100.
You will get 83.
My lord. Now, if my lords will, we're just passing on the illustration based on the this is the calculation, my lord, that is to be undertaken based on this.
How are you calculating 83?
My lord, 98 because he comes down by 15 marks. He comes down by almost 18 plus. I'm sorry. He comes down
28.
78. 78.
No, if 18 plus 10 is 18 plus 10.
And 5. Because he gets only 5 marks for this, having corporate office outside the state of Bihar.
Where is that outside? Yes.
So 18 plus 5, 23 marks.
75 you will get.
He loses 23 marks. 75 he gets, Manoj. So this is the calculation sheet, Manoj, that we have prepared on the basis of the formula that they have given at page 47. Based on QCBS.
You don't know calculation.
My lord, we are not asking the court. We are only showing for my lord's perusal, my lord, that based on this, my QCBS score based on whatever marks that they've given to me is 82.5. Petitioner's QCBS at the rate 75 marks in technical, it comes to 82.5. And bottom of it, my lord, will find the RSPL's QCBC comes to 81.8 if it is reduced to this. If it is reduced only by 5 marks, then also he goes below my total marks.
But you have been awarded 75?
I have been awarded 75. So based on 75, my QCBS score would be 80.
You will also get 75?
He also gets 75, but if his marks come down even by 5 marks, even if he comes down to 93, his score goes down to 81.8. Because my bid so far as the financial bid is concerned, my lord, mine is much lower than his. My bid is for 5.01 is the service tax that we have given, service charge, and their financial bid so far as service charge is
113. If his marks is reduced by 23. One respondent and you will get.
But because my financial bid is lower than his, so I get higher marks. Weightage is given, 30% weightage is given to the QCBS under the QCBS scoring pattern, my lord. Because scoring is done as per page 48, and if my lords will kindly have a look at page 109, my quote for financial bid is 5.01.
Page 48.
48, my lord.
What is it? Where is the financial bid?
My lord will find that at 109.
And what is this page 48?
48 is the formula for calculation. All these figures have to be placed on this formula, and if my lords will kindly see page 109. My lord will see page 109.
Oh, 109.
My lord will find that 5.01 is my code, and his quote is Rakshak Secretary, the last column is 9. So, because of 9% of service charge. So if that is transposed on the formula, his total score goes up. My score goes up and his score comes down because only 30% weightage is given in this. That is all.
Yes, sir.
Lord, so far on grounds, my learned friend has raised to the marking of registered office, corporate office and registered office. These two words of theory, corporate office and not registered office in Bihar and outside Bihar. For Bihar, there is a 10 marks and outside 5 marks. Respondent number 7, Lord, admittedly a company registered under the Companies Act 1956. Their registered office in terms of Companies Act Section 34 is at Delhi. But the respondent number 7 is registered here under Bihar and Shops Establishment Act, as also under Bihar Private Lot Security Regulation 2005. Now comparing petitioner is a proprietary firm. The word corporate and registered office is technically applied. Then petitioner a proprietary firm registered under Bihar Shops and Establishment Act like the respondent number 7 and has got its office here. Similarly, respondent number 7 is also registered under Bihar Shops and Establishment Act and they have got their offices here. So both have been allowed equal marks.
No, registration is required to be taken with reference to which act? Companies Act or?
No, so in my humble submission, if is strictly given meaning that like State Trading Corporation of India Act other cases, while Section 34 was considered below their losses say, when the company is registered under Section 34, then it becomes a legal person and the shareholders become the corporate. This corporate and registered word has to be given below the natural liberal commercial terms. If this is strictly applied in terms of company law, then petitioner comes nowhere.
Sir?
Will not be treated as a corporate.
Then where do you get this, how it is required to be interpreted? Registered corporate office.
My submission is petitioner is registered under Bihar Shops and Establishment Act here. They have got their office. The respondents.
The petitioner firm is not registered under the Companies Act?
No, they are not. They are individual. They are proprietary firm only. So this the respondent 7 has one additional thing that it is a company registered. But comparing with the petitioner, both are registered here under Bihar Shops and Establishment Act.
No, if the petitioner company is not registered under the Companies Act, then they are also not entitled to this 10 marks.
So I say, by humbly submit, if this interpretation which my learned friend is putting before your lordship, corporate and registered word, is strictly if taking technicality under Section 34 of the Companies Act, then petitioner is not registered. It is all. I assume against myself. But both are not treated equally because both the petitioner, a proprietary firm, is registered under Bihar Shops and registered block under Bihar Shops and Establishment Act, called an establishment here, like the respondent number 7. That is also registered under Bihar Shops and Establishment Act in Bihar. So both have got equal status in regard to that clause. Rather, the respondent 7 had got a better title of a company having its registered open Delhi.
So we have to give the interpretation with reference to registered corporate office.
Yes.
With such a registered corporate office is reflected only in the Companies Act.
So I humbly submit below that if the 10 marks both is deleted, then equally then the next question will be for my lord consideration about the experience, which my learned friends say. Now, so far this respondent number 7 is concerned. If your lordship take the second time, then petitioner will be out, but respondent number 7 will get 5 marks. Corporate and registered office outside Bihar.
But in column number 2, he will get 0. He is not entitled to 18.
My son is that so far
18 is 18 plus 10. 28 is reduced. Then he will get 75.
So far, Milord, first issue about registered office, I am arguing that if petition.
No, according to you, 7th respondent registered where?
In the registered respondent 7 is a company registered at Delhi, but they have got their registration also in Bihar under Bihar and Shops and Establishment.
Where is that Shops and Establishment Act?
That we have recorded that Bihar Shops and Establishment Act. On that footing, both are self-registered petitioner as well as this respondent.
No, you can't take under this Bihar Shops and Establishment Act because there is no definition of corporate registered or registered corporate office.
If my lord will see blood, if your lordship take trouble, this the certificate, the registration certificate issued, it is issued under Rule 3 Bihar States of inform.
No, first of all,
certificate of registration. Annexure C to the counter affidavit of respondent.
This is the difference, sir. This Shops and Establishment Act governs a different set of.
In that case, on this ground, the petitioner will be is registered under this act itself.
That even both are not entitled.
Now the second part is, so far the respondent 7 is concerned. In that case, the respondent 7 instead of 10 marks will get 5 because it is a company registered outside Bihar.
Sir, company is not registered.
That is not a company, my lord.
It is not registered under the company.
No, my lord, not it is not. It is only registered under Bihar Shops and individual.
In that event, the petitioner is also not entitled to any marks under item number 6.
In the counter affidavit, we stated all the facts, and the certificate of registration of both under the Bihar, if your lordship, adopting your lordship's observation by submission, that both are registered so far in Bihar is concerned under Bihar Shops and Establishment.
Correct, but the Bihar Establishment Act and rules does not prescribe any registered corporate office.
Your lordship will kindly see the registration certificate issued under this act, Rule 3.
Rule 3.
Yes, Form 3. This is the certificate issued annexure C to the counter affidavit, the copy here. This is the book case applicable to both. Equally, the listener, in an individual, not a company, not a firm, an individual, and the respondent number 7, a company. Both are required to be registered if they intend to have a business establishment in the state of Bihar. They are required to be registered.
Sir, this is rules, the Bihar Shops and Establishment 1955 is related to registration of establishment.
That will not hurt. So both are registered, both are states on equal footing on this ground. But this
register is also not entitled to any marks under item column number 6.
But the page 46, your lordship has seen the second is Page 46 of the writ application, the NIT speaks of Bihar registration marks 10. Nobody that will get, neither the petitioner, but respondent number 7.
They are not entitled. Column number 6, they are not entitled.
In the bottom, your lordship will see at page 46, registered of the writ application.
43.
46.
No, 46 only. Residence in Bihar. Registered corporate office in Bihar.
Then second line will be registered corporate office outside Bihar.
Yes.
5 marks. So respondent number 7 will get in that case 5 marks.
That he will get 5 marks.
5 marks. Now second the challenge to my learned friend is that respondent number 7 has no experience of 15 years, 8 months. Your lordship kindly see the documents and experience certificate placed by respondent number 7, which were taken into consideration, is annexure B to the counter affidavit of respondent number 7.
Annexure B to the?
B to the counter affidavit of respondent number 7. Page 24. My learned friend had shown something which he had downloaded from the website without disclosing what is that document.
What is this document? Annexure B.
This is Annexure B is the certificate, documents of experience and places of works. The respondent 7 had been.
This is relating to respondent number 7.
Yes, blood. 7 respondent 7.
We'll do one thing, we'll set aside and allow the petition and remand the matter to the concerned authority. He will re-examine the how to award examination marks.
So but this experience certificate is the part of bid document. Bid document. This bid document is this certificate is blocked.
Fresh exercise, sir.
Annexure B, your logic I see, prima facie, because what is happening beyond our transmission unit. The petitioner had only working Milord up to 31st of March 2023. Now, presently, the respondent number 7 had taken charge of it was divided in 3 zones: Muzaffarpur, Bhagalpur, and Patna. Petitioner was only allowed for Patna was work doing. He was not doing all others. Another writ application at serial number 34, your lordship will file. Has been filed in respect of very day by another person, L3, who had was allotted work for Muzaffarpur zone. So now respondent number 7 had taken charge of other places. Because security after.
You saw everything for a week and undertake exercise of re-evaluation.
Your lordship will keep it pending. We will submit report to your lordship. Your lordship will get a second thought. And in the other case, Lord, without making.
Doesn't have any. Cannot have.
Namila, you would add you had fallen from your lordship. Lord, I get this respondent 7 gets 5 marks on the in regard to corporate office and registered office. Still, that will remain above the petitioner. And so far, experience certificate, Lord, declaration has been.
Sir, we cannot experts. Therefore, we will leave it to the concerned authority, who are technical persons. They can award marks while undertaking fresh exercise.
This respondent 7 has got the experience of security from 2006.
To undertake exercise within 1 week or 10 days. And we list this matter, release this matter after 10 days, you produce the re-evaluation. Any other bidders?
No, Lord, item number 34. They have filed this application, but the company not made party even in that.
We are listed at serial number 34, sir.
What is your name?
Dev Prakash Singh, Jayasankar Security. Jayasankar Security. Jayasankar Security.
Huh?
Jayasankar Security.
No, sir. Jayasankar
Industrial Security, yes, sir. I am L3 there.
Their names is not there? Their name?
No, this is 34 was L3.
L3 due to and marking pattern because I am a corporate registered officer in Bihar.
Your lossy will see.
We'll hear separately.
This would amend the writ application. Company itself not made party. Only the state officers have nothing to do. State of Bihar, Energy Secretary, State of Bihar.
Have been included as party.
Company not made party. Transmission company.
Lordship, in that case, I have already filed a Vakalatnama, but my name is not appearing on the list, Your Lordship. And I have also
take it separately.
Get the counter affidavit also, Your Lordship.
All right, sir.
Points are similar, Your Lordship. In this case and that case, Your Lordship. Almost identical points, the same thing he has raised.
In the meantime,
whatever it may be, we have heard this. We are passing order. Petitioner has questioned the
Before Lordship, may kindly Lordship.
Award of work under NIT number 30
Lordship permission
/PR/PTCL/2022 to the 7th respondent dash Rakshak Securitas Private Limited. Further sought for various directions.
Only with Lordship permission. Only one line I want to submit, Your Lordship. Only one.
Yes, sir.
Lordship permission.
Permission. When you are asking, you have to give.
No, Lordship. That's not the thing, Your Lordship. Just humbly I am taking permission just to point out, Your Lordship, that is annexure B series, which is the experience, Lordship.
Sir, we are not, this court cannot re-examine what is the marks is required to be awarded with your experience certificate. We are not experts.
No, only they have filed fresh document. Only the document submitted that should be made clear.
Sir, it is left to the authority who is assessing.
Obliged.
Main contentions urged on behalf of the petitioner is that 7th respondent is not entitled to award of marks under the head of experience of the eligible security service business upon submission of satisfactory performance. The following manner: 5 years and up to 10 years, dash 10 marks. 10 years and up to 15 years, 15 marks. 15 years and up to 20 years, 80 marks. 20 years, 20 marks. Full stop. In this regard, award of 18 marks to the 7th respondent is in the absence of material information. Full stop. He has pointed out that 7th respondent do not fulfill even 5 years of experience so as to award 10 marks to him. Therefore, award of 18 marks to him is contrary to material information placed by 7th respondent along with the bid. Similarly, so far as the award of marks with reference to presence in Bihar dash maximum dash 10 marks, registered corporate office in Bihar is entitled to 10 marks, and the registered corporate office or registered corporate office outside Bihar is entitled to 5 marks. So, on this point, Land Council for the petitioner submitted that Securitas Private Limited company was registered. Company was the registered corporate office in Delhi, New Delhi. Therefore, award of 10 marks is contrary to material information. On the other hand, for having registered corporate office outside Bihar, at the best he is entitled to 5 marks instead of 10 marks. So it is further submitted that formula at page 48 read with the financial bid is considered. In that event, the petitioner is entitled to petitioner would be better footing than the 7th respondent. Full stop. Next paragraph. Per contra, Land Council for the respondent resisted the aforesaid contentions of the petitioner and submitted that both the 7th and respondent and petitioner their office is registered under the Bihar Shops and Establishment Rules, 1955, and their office are registered under Rule 3 of Rules 1955. The same has been taken into consideration. So, in the event of registered corporate in the event of registered / corporate office in Bihar or registered / corporate office outside Bihar, taken into consideration with reference to Bihar Shops and Establishment Rules 19 Act and Rules 1955. In that event, both are entitled to certain marks and which has been awarded. Full stop. Petitioner is not a registered company, it is a proprietorship. Therefore, the petitioner have registered their office under the Bihar Shops and Establishment Rules, 1955. If award of marks under item number 6, presence in Bihar dash registered corporate office in Bihar or registered corporate office outside Bihar. With reference to registration of a companies under the Companies Act, so and so. In that event, petitioner and so also seventh respondent are not entitled to award of marks under the head of presence in Bihar dash registered corporate office in Bihar or registered corporate office outside Bihar. At the same time, it is submitted that seventh respondent is entitled to award of 5 marks instead of 10 marks for the reasons that seventh respondent company was registered at New Delhi and it would be considered as a registered corporate office outside Bihar. If these marks are altered, even in such an event, the petitioner is not seventh respondent is better footing than the petitioner with reference to calculation of marks read with the financial bid. Seventh respondent, next paragraph. Learned counsel for the seventh respondent reiterated the arguments advanced on behalf of the respondent 3 and 4. Further, he intends to apprise this court with reference to the experience certificate by Annexure B series to the counter affidavit. Yes, sir. Courts are not expert body to assess and award of marks with reference to technical experience and other issues are concerned. However, we prima facie find that while award of marks in respect of item number 2 and 6, insofar as seventh respondent and petitioner are concerned, it has to be revisited by the technical persons in the office of the respondent 3 and 4 and undertake fresh exercise of award of marks. This exercise shall be undertaken by the concerned / authorized persons and place it before this court before the next date of hearing. Release this matter after 2 weeks.
Your Lordship, like your Lordship has granted the interim order in favor of petitioner. Because on the date of grant, petitioner was continuing pursuant to an extended order. As on date, that has expired on 31st of March. So we have to take care of the installation throughout transmission. Your Lordship, very troublesome work.
They've already removed us.
What is the alternative?
He has removed us.
So we should doubt that much, your Lordship.
What is that alternative you are going to undertake?
That the respondent 7 have taken charge below. So in the meantime, he should continue subject to my Lord's decision. Because we have.
And counsel for the respondent 3 and 4 submitted that up to 31st March 2023, the petitioner was permitted to execute the work.
For Patna zone only.
The respondent has taken charge pursuant to the NIT, which is the subject matter of this present litigation, to stop. Therefore, execution of any work by the seventh respondent till disposal of the present petition is subject to result of the present petition.
May I make a request, my lord? My lord, if the revaluation is to be made, it may be made in the presence of the parties, my lord.
You will also give a copy.
In our presence, revaluation in our presence, my lord, before them.
Evaluation will not on the basis of documents with the will.
Documents only. Why you are?
He
Now they are
has
disputing, my lord.
30 documents he
What
has
is
supplied.
there that has been uploaded on the eProc side, the different documents that had been submitted by respondent number 7. Now they are saying that now they are, by virtue of annexure B.
Number 3 and 4 are hereby directed to provide a copy of the reassessment of award of costs to the respective parties in advance.
On the basis of below documents uploaded, they have 30 document, bunch of documents.
No, whatever it may be, as on the last date of submission of NIT
That is
application.
That word will do.
No, why? That everything is required.
They are brought on record, my lord, by way of annexure these documents which are not there on record.
Because then you have uploaded so many documents subsequently to fill up the blank.
And secure the records also.
Serial number 34 also will come.
I beg to submit something, sir.
No, in the previous matter,
Because if I properly marked,
secure the original records in order to ascertain as to whether the concerned respondent has taken note of document and material information with reference to last date for furnishing the tender bid.
So far, it is for my because we can't file a company has not been made party, and my learned friend says कि जब आप chairman को बना दिया तो so on behalf of your lordships have held that company and directors are distinct and separate.
But the managing director is there.
managing director is there, state of the art of president, secretary is there.
You seventh respondent.
Both this he has appeared in that case also.
I have filed the wakalatnama, Your Lordship. Though my name is not appearing.
My lord, kindly allow me to submit something more.
Fifth respondent counsel, Mr. So and so. The Mr. So and so counsel accept notice for respondent 2 to 4.
Yeah.
2 to 4. Respondents are hereby directed to file their counter before the next set of hearing. List after 2 weeks.
My lord, the serial number 34 should be allowed to submit something more.
What something?
I am the
No, they must be heard, no?
Yeah.
You want expert interim order?
Serial number 31, Dheeraj Kumar Pandey versus the State of Bihar for the petitioner Sri Praveen Kumar.
Lord, in this case, I am for the petitioner. Lord, the last week, Your Lordship, last working day, I have received the copy of the counter.
Last week?
Lord, the copy of the counter I have received. Lord, it needs a reply.
They have filed counter. You want time?
Lord, 4 weeks time may be granted.
Counsel for the petitioner seeks time to counter affidavit. He is permitted to file. Petitioner is permitted to file a rejoinder if any before the next set of hearing. Is this matter after 4 weeks?
Oh, Lord.
Serial number 32 is that is withdrawn. Serial number 33 is adjourned for 1 week. Serial number 34 is adjourned for 2 weeks. Serial number the ready for hearing. Serial number 35 Bihar Fruit and Vegetable Development Corporation Limited and others versus the State of Bihar others for the Pizza State Nani and Joseph Tiwari.
Where is the award?
Lords, the award, my lords will find.
They have not gone to the award, my lords are
Annexure
talking
2,
about.
page 16.
The award.
Annexure 2, page 16 of the rate application. My lords, in order to bring a quietus to this entire matter, when this matter was being heard by the previous bench, by a coordinate bench, it was suggested by the bench itself, us, I mean, we are the workers who have been fighting from rate up till now, that whatever amount the corporation has calculated as the amount due to us for the period 4/7/2007 to 39/2016, 2007 to 39/2016, 39/2016. This is the amount which the corporation has itself calculated as the amount payable to us for this period, and they have brought the entire names of the workers and the respective amounts that is due by their 6th supplementary affidavit, and they have annexed the chart also as to how much amount is payable to the workers. They have admitted that this is the amount that is paid. And we informed the coordinate bench earlier that in order to bring quietus, we will be happy if this amount is paid. We don't want to contest this matter any
My lords,
further.
may kindly have a look at the order dated 25/11/20. That would suffice, my lords. 25/11/20.
So this amount has been deposited pursuant to orders passed by this honorable court. And
by 11?
25/11/2021, my lords. 21.
My lords, prior to that, just 3 orders may be seen. Direction was given, you pay them this amount. They didn't pay, then the court ordered that you deposit this amount, and the amount is lying with the registrar of this honorable high court. So if that amount is released to us, we don't want to further claim anything from the corporation. We will be happy and we will be satisfied with that amount.
11/2021.
My lords. 21, my lords.
2021.
क्या है? हाँ, वही 25,000. वही बात वो हम
No, once you have deposited 1.53.
Exactly.
There is a question of re-examining.
I would, that is what I would like to clarify. My learned friend had submitted that. That amount was with respect to the actual wages which they would have earned till 2016. We had contested that since they were removed in 2007, only the compliance of Section 25F was not done, and henceforth we paid them till 2007.
No, this 1.53 crore.
This was
calculated from 47 to 2000.
My lords, to 2016 only because this order was being passed in 2016. That was the reason. Thereafter, my lords, as my lords have seen the order, the Honorable Court said that fine will come down to a one-time compensation. You get an amount decided by if the board approves it. But unfortunately, my lords, the board rarely sits. It has still not sat, in fact.
My lords, there are specific orders passed by your lordship.
I know. But
directing them to pay this amount.
What I humbly submit, my lords, that was with regard to wages. So it's not that the entire amount has to go to them. What we had also contended there, my lords, a lump sum amount, compensation, as in line of various judgments of the Honorable Supreme Court, even my lords have passed in many cases, that a lump sum amount compensation to the this writ petitioners.
How many years they have put in?
And we are here from
the corporation had started from 80, become defunct in 85, 89. It became defunct. No work from there.
Supreme Court principle is taken into consideration.
My lord.
I think 25,000 rupees per year.
Then they will be at loss, my lord.
It will be at loss, my lord.
Please agree.
And we are ready to accept that amount.
We have agreed on that, my lord. The only now issue is the interveners. My lord would find there is.
What is that intervener?
The interveners, they were removed.
Can I clarify, my lord? Now, interveners have jumped in at this stage for the first time. I'll explain it. We are 22 of us.
No, intervener filed the application in LPA.
In LPA.
That has been allowed.
They were not.
That has been allowed.
They may have been allowed.
2017.
They were not part of the writ application. They did not file the writ application.
They never challenged the case that we were not.
All right, we are allowing your intervener. Do you think that you are entitled to relief?
If you
and their writ is pending. Still pending.
And there is a writ also pending, filed by them. So their writ may be segregated.
Situated.
Let the writ be decided. Let me relegate.
Pursue your writ. Your services were terminated on what date?
Lord, exactly as Lord, the respondent are there.
No.
We are part of the award, Lord.
2007.
No. Sorry, let him.
2007. Where is the challenge?
Lord, that has been challenged. That is the part of the award, Lord. Our name is there in the award, Lord.
Then go and execute the award.
Exactly. They have not even gone to the.
Go and execute the award.
Now, if your Lordship may kindly see, Lord, the order dated 12/12/2017, order number 15, Lord, in the present proceeding, Lord. Your Lordship may kindly go through that order, Lord.
15.
15, order number 15, Lord, 15. This is dated 12/12/2017.
How is it relevant for you?
My lord, the last 4 lines, my lord. The amount shall be paid to all the employees who are entitled to the benefits, including the interveners who have filed the application for intervention.
But he's not similarly situated as such. He didn't
Lord, I
challenge.
fail to understand, my lord. It is the corporation who has...
Clarify.
Lord, what I am submitting before your lordship is that it is the corporation, my lord, who has to pay the amount. Now, why, my lord, the private respondent, the writ petitioner, my lord, are opposing?
Because that money has come for us.
No,
It
no,
is
it's not the
mentioned.
fact, my lord.
No, they will get reduced amount because they have to.
Lord,
1 crore 50.
Our name is there in the award, my lord.
He wants to take the money from
That
us.
is the reason, my lord, in the
benefit
last
himself.
occasion which my learned friend, my lord, appearing for the appellant, he has pointed out the last order of 2021, my lord, November 2021. In there also, my lord, our consideration is there, my lord, in the order.
That was the reason, just one line to add, that was the reason why his writ was directed to be listed also. Because it was our contention that they are not entitled. So let me relegated to the Honorable Single Judge. Let it be decided. He can challenge that if.
Lord, that way,
Sorry, you can claim independently before the writ court.
My lord, that is what.
Taking shelter under this. We are
my lord, after allowing the intervention, my lord, the amount was calculated, and then, my lord, it has come that it is 1.5.
Then it will be transmitted to single judge.
Lord, that lordship
You can't decide your case on merit. Because your case is required to be decided on merit.
Lord, what I am submitting.
Here we are not deciding on merit.
And
we are deciding on the compromise.
And my lord,
in the earlier proceeding, my lord, the appellant, my lord, he has agreed for giving payment to the intervener.
No.
Yes, my lord, that is the order which is saying, my lord.
Never, my lord. Never, my lord.
My lord, if your lordship may kindly see, my lord, the order which my lord said was just referring.
My lord, 1.53.
This 25/11/2021 order, my lord.
My lord's 1.53 which has been deposited. In that chart which my friend has calculated, the corporation, the names of the workers are mentioned, how much amount is to be paid is mentioned, and we are the only ones in that. And that amount was directed by this Honorable Court by order dated 3/8/2018 to the
You have produced that list.
Yes, list is there.
That rate is attached in the present case, my lord. If your lordship may kindly see, my lord.
That is the
both cases are attached in the present proceeding, my lord. The rate is also by the order, my lord. The rate is also there before my lord, my lord. The writ application, my lord, in the present case is also there.
As intervener's name is reflected in Annexure 6.
No, it's not there. 6th supplementary affidavit filed by the corporation.
Yes.
No.
There are 30 names.
My lord.
There are 30 names. Yes.
Show us your name is reflected.
All these persons whose names are there were removed on 3/7/2007. We are the ones. He was not even removed. And in fact, his writ is here. My lords will see the prayer what he is making in the writ. He is not even challenging because he was never removed.
He was never removed, my lord. And they were paid all the dues, paid the 1 month notice, and in lieu thereof, payments made and then removed. They never challenged. They got emboldened only when their order came.
When they are saying that since we are getting some money, so now they have joined at the last moment.
It was filed in which year? Their rate?
Their rate is of
2013. And we are challenging we had removed this.
So 2013, appeal is also of 2013.
No, it's the appeal. The original rate is of 2007. I don't appreciate.
We filed our rate in 2007.
Lord, I'm just pointing out.
This chart doesn't show their name, and this is a chart made by the corporation. My lord will kindly see 6th supplementary affidavit filed by the corporation, and it is this amount that your lordships ordered to be deposited. My lords, page 11 of 6th supplementary affidavit.
Yes, sir, we have seen it.
And it is this amount, so it has come only for persons who are mentioned in the list specifically.
Do you think that we don't understand?
I'm sorry. Yeah.
8 persons, my lord, their name are there in the award.
So not award, in page 110, counter affidavit. If you are relying on award, go and execute.
Lord, that is there, my lord, in the...
Execute, go and execute.
Lord, the next case which is attached with the present case, my lord, is the writ application which was filed, your lordship, by the interveners.
We will restore the matter to single judge.
My lord, that has come, your lordship, perhaps, if I remember.
All right, we will de-link and place it before the appropriate bench. But you people have to give undertaking, no?
My lords may record that. Or if my lord wants, we can file a short affidavit also. Say once
with all these 30% signature.
No, my lords, we are 22. All 22 will give an affidavit.
It will be restricted to only 22.
My lords, only 22 are fighting the case. No, not 30.
But
the other persons.
We have been generous enough because 30 people had actually been
Similarly
situated. So we gave 7 others also. We gave them, my lord.
So
the earlier part, not this part. The money deposit here was not here.
He has been
as far as these petitions.
All right, give 22% undertaking.
Yes, my lord.
But we will accept this.
Exactly.
Yes, my lord.
We will not claim anything.
Yes, my lord.
But the only amount, my lord, the undertaking would be only on behalf of 22. But the amount is of for 30 people.
We don't want
30 people.
We will
my lords, that amount.
refund the balance amount.
My lords.
And but you have to disperse in those names.
Exactly, my lords. In specific.
And don't say that they are not before this court.
No. I'll be disposing.
My lords.
And one more consideration, my lords, because I need to point out, because I've been facing another litigation. One of the petitioners, they have also, though these as my lords also aware that in lump sum payment of these kinds, PF amount is not separately paid. But one person has been pursuing in a PF amount and there hasn't been order.
Once he gives an undertaking,
exactly,
depending on him.
That is what I was trying to point out. They would say that it would be a lump sum and no further payment.
My lord, so far as the dues or whatever is involved in this rate, etc., we are going to say that once we receive this amount, which is mentioned in this chart, then we have no further claims over corporation.
My lord.
We are willing to
that would suffice, my lord.
Even undertaking, sir, that this is final settlement, and we will not claim anything.
Any dues under the head of salary and wealth, we will not claim it.
My lords, that would help.
Affidavit.
My lords, within 2 weeks, because I have to collect it from everybody.
The matter for some time.
So far the other persons are concerned,
we will reject. Go and approach a single judge.
What submission is not, your lordship may kindly take into consideration. A reference order award is in our favor. It was challenged before this Honorable High Court.
The single judge is the better person to decide your case.
But there is a problem.
Here, sir, now here it's only a compromise among the petitioner and the petitioner and respondent. You can take shelter of this document before the single judge and also request identical, our matter is also identical, give us a similar benefit. It will be examined by the single judge.
Judicial order for placing the case along with the present case, so we are. Otherwise, if there is an order by your lordship for the matter, then
we would have decided, provided if the petitioner agreed. Petitioner is saying that the petitioners in CWJC have not been terminated on 4/7/2007 and they are not similarly putting on the respondents in the LPA. Therefore, matter requires some argument. It will be listed before single judge.
Personally, my lord,
heard the matter first.
What my learned friend who is appearing for the appellant is saying, my lord, it is not the fact, my lord.
All right, you establish before single judge. Heard the matter for some time. Application LPA have already invoked writ jurisdiction, and it is reliably learned that there is an award 22/7/1988 in their favor, In the reference case number 1 of 1987, the light of these facts and the fact that the petitioner corporation are disputing that intervener applicants are not similarly situated to that of respondents with reference to date of termination and other material information. Therefore, intervener application applicants are not entitled to any monetary benefits in the light of sixth supplementary affidavit filed by the sixth supplementary affidavit read with Annexure 6. They are not entitled to have any relief. However, denial of any relief to the intervener applicants would not be a hurdle in deciding their writ petition number 12522 of 2013 and connected petitions. Accordingly, CWGC 12522 of 2013 and connected
That's the only case, man.
No, is restored on the file of learned single judge, who is a single judge is requested to decide the CWJC 12522 of 2013 at the earliest. Registry hereby directed to list CWJC.
May I venture, my lord?
The next paragraph. LPA 270 of 2013
may I seek your lordship leave to say one word, my lord?
in the light of order dated 25/11/2021 read with the supplementary affidavit along with the Annexure 6. The concerned respondents are hereby directed to give an undertaking that their claim is only restricted to Annexure 6 and they would not claim any other benefit. Such affidavit shall be filed before the state of hearing list this matter after 2 weeks.
May I seek your lordship permission, my lord, to say one word, my lord, that since, my lord, the matter is again being sent to single judge. Since, my lord, the matter is again being sent to single judge, may I pray that your lordship may say, that will be my humble prayer, that your lordship is not expressing any opinion. Your lordship have your lordship have referred to the submission of the other side. So probably it may
be observation made in this order would not be a hurdle for deciding CWJC 12522 of 2013
on its own merit. Obliged. Sometimes it is said, my lord, that the division bench has expressed some opinion, though they have referred to the submission in Annexure 6, all those things, so we will not be hearing anything. So that your lordship.
What is the date of termination?
Termination is 17. No, 19.
Where is the document? Termination order.
Our counter has, my lords, way back in 1991.
Where is the termination order? When the cause of action accrued to the petitioner?
Which application of those three facts are there below?
All right, go and address the argument before they learn single judge.
Yes.
There is one more LP, my lord.
Over here.
Same. Serial number 36, the state of Bihar others versus Ram Babu Singh for the appellant Sri Manoj Kumar.
Your Worship, in this case, there are 4 LPAs connected with the same issue. And as per your Lordship last direction, they have served 8 affidavits
I have served
to
copy
me.
with the other side.
So we need to examine the same, your Lordship. Today it has been served.
Subject to Lordship permission, one identical matter Lordship had listed on 15th April. Lordship may list this matter on that day itself.
What is that they have filed?
I have not gone through it. Today.
No, what is that they have filed? Is it counter affidavit? What is that? Supplementary affidavit?
Supplementary Lordship have filed at Lordship direction. To substantiate my appointment, I have filed the orders of the apex court as well as the certificate that suggests that after
one of the respondent is stated to have filed a supplementary affidavit and petitioner intends to use the same. Release this matter after 2 weeks.
No, there are other cases, we all made it, and a lot.
On 20th April.
There are 20 appeals together on the same point. In fact, against the same judgment, relying also. All if is tagged together, my lord has already fixed date on 28th, and the others are.
This matter on 20th. Don't club it, just list on the same day.
one